They say that, my lord, the property was about to be disposed of. Cause of action arises that is what this court in 2025 held, my lord. In Kudallur Power Corporation case, this court held that they need not wait at all.
In the second suit for specific performance,
Specific performance.
in the meanwhile, what happened to the old suit? It got withdrawn.
No, no, my lord. Yes,
of
after the filing of the suit, it was withdrawn, my lord. Not prior to that. The suit was filed and it was withdrawn, my lord. That may not be the correct approach, my lord. And no leave was granted.
Should we be interfering is what we are thinking.
Let-
Okay, you have a point,
Yes, my lord.
but then not.
My lord, if your lordship is pleased to see, my lord, High Court said that,
Well, not really.
my lord, High Court entered into a finding that, my lord, leave was not granted, my lord. You kindly see the order, my lord. They just withdrew the suit. Leave was not granted at all. Could your lordship?
I was just thinking whether. Okay, all right.
Lord,
All right, issue notice.
my lord, I have requested for a stay, my lord. Otherwise,
Status quo, status.
as your lordship, oblige.
The marginal case, that's why we are just thinking. Let the other side come. we'll see.
Yes, your lord. Oblige.
Yes, here in this case, my lords, if your lordship looks at the sale deed,
Trial court dismissed.
page 17, this is a sale deed. My name is mentioned in the sale deed as the owner of the property.
Allow करके dismiss कर दिया सुन.
My case is that it was a case of impersonation. That is my case in my plaint. So, my lords, when I am pleading fraud and impersonation, my lords, section 17 would apply. And from the date of knowledge, it would come in. And from that, my lords, I have filed it within limitation.
Notice करना.
But it cannot be done in 711 stage.
Issue notice. Issuing notice.
Yes, I am grateful.
Similar matters we have discussed. We have
My lords,
discussed similar matters.
Yes, my lord.
8.
May it please your lordship kindly adjourn the matter.
No. Where is the question of adjournment?
If
Don't be so casual. Just ask and ask. Come and ask for
the
adjournment.
the senior
Do
is
such things.
the
If you
senior
tell your senior, I will not do it, sir.
sir, kindly adjourn.
And your
If
senior can't ask you to do that. Just come and ask for adjournment.
he's
Pass-
tell sick, yes.
Passing out over, get ready and come. 9, item 9. No, he is suppressed at this. That's the way, correct. He suppressed that fact. Pass over.
Well, as in 10, I appear for the discom, the state discom. This is well as completely wrong.
Parallel operation charge.
And just note two things. Parallel operations, they accept that they are connected. Technically, physically, they are connected. They accept that there are huge benefits.
Nothing but grid support charge only.
Only ground on which is
Is only-
formally they don't apply. So
Is
de
some-
facto they get.
Yeah, you keep on increasing the jargon more and more.
Yes,
It's a grid support charge only.
Correct. It's a grid support charge. They are connected to the grid and they get benefits. Their written submissions admit factual connection, but they say the impugned order reversing an order in my favor holds that because they formally did not opt for it, they are excused from all the charges. Now see the 3 pages, but just see that admission by them. Turn to page 46 first, 42 first, page 42. It's a huge loss to me, Malas. 40 of them, 493 crores. Nobody is paying a single penny and getting the benefits. Just turn to that benefits also, Malas. Turn.
Formal option.
Come to 42, Manas. Please come to 42. My lord, take 42.
Okay, we'll issue notice. Take notice.
So that's one, Manas. Second
Take
thing is,
notice in the-
in fairness, at least going forward, they must pay POC charges. Arrears are 493. Arrears are 493 crores. 50% of that I'm asking,
Take note.
subject to my law's discretion.
The case was cleared.
So I'm saying, well,
Notice, let notice go, we'll see later.
so well, just appreciate the dynamics, the lordship will decide. 493 for the past, not a penny. No guarantee. For the future, they are going away clean because I can't disconnect. With this judgment, I can't disconnect for the future also.
And they will not apply. They're not
And
applying.
just see the benefit. Maybe 2 minutes. Lordship will see the benefits they are drawing. Just turn to page 76. Just for 1 second.
It's about the.
They are drawing all benefits. And they are what they have got away on is a formal application I have not made.
They have not.
Turn to 76. But
We'll examine it.
We never
Let
opted
them
for-
apply.
File your,
some equity should.
file your counter and interim order, we will pass orders.
Yes. Lordship may must keep that order. I keep it on notice on the interim also and keep that option alive early in January. Malus.
Issue notice on
Early in
main as well as.
Early in
interim
January.
application. Just let them respond to that, then we'll.
Deeply
We
aware.
will do that.
Well, early in January, please give an actual date. Malus.
Yes.
Deeply aware.
10th date, any date, mailing.
Excuse me. Your Lordship, in this case, the recorded tenant died without any legal heirs, and the revenue authorities decided in the favor of the plaintiff.
Option का नहीं हुआ.
Your Lordship,
Right क्या है? है ना? It's notice.
Lordship, stay of the impugn order. Lordship.
What is the stay?
Your Lordship,
What is the stay?
I will
What
be
is the stay?
evicted
It's
from
only
the
on the
premise.
principle, that's all. By virtue of this, what will happen?
Your Lordship, I may be evicted from the suit property in question. Your Lordship, that's fine.
You are the state.
Lordship,
What do you mean by evicted? इसको क्या? Eviction. Which item are you appearing? 11. Where is the question of eviction? Where is the question of eviction? All through it's gone. Anyway, take notice, take notice. We will see later when other side comes.
Your Lordship, item 12, I'm requesting that we have to file some additional documents. And Your Lordship, other connected matters are coming up on 5th of January, Your Lordship. These are all
We'll
special.
post along with them,
Yes, Your Lordship.
post along with other connected.
Still the
We'll
award.
issue notice in that. Where are you? We are issuing notice. All right. Post on issue notice.
Your Lordship has dismissed the SLP with the observation that they may recover the amount from the.
It's not a
contractor.
contempt of Supreme Court's order. We only
They
dismiss
have not
SLP.
complied even though.
You
for
don't
the
come
last time.
here when we dismiss an SLP in contempt. You go to the primary
Then
court
liberty
for
may be granted
implementation
to
of the order.
move the High Court matter. Liberty may be granted to move.
Permission to withdraw to move the High Court. Dismissed is withdrawn with permission to move to
Liberty.
appropriate court.
Item 14, mutual assistance procedure is only for that particular year.
Similar matters were dismissed.
On delay,
Same identical.
Deeply obliged.
Same order, same order.
Item 15, I'm being led by senior advocate. He is connected.
May I, my
Similar
lords?
matters. 15.
Similar matters, your lordships have
Similar
dismissed.
matters we have dismissed.
My lords, kindly permit me to only make one sentence, my lords. I am a purchaser of the property during the pendency of the suit. However, my lords, from 1970, my predecessor is in possession of the property. And my lords, the court now, High Court very strangely holds that it is for the authorities to decide whether defendant is still entitled to hold the property or not.
Same order.
Before that is done, my lords, I am now directed to hand over possession.
Common judgments, very same judgments, SLPs are dismissed by the court.
My lords will kindly see page 31, my lords, the finding is completely contrary, in fact, unknown to law. The High Court.
Telling you the identical matters.
Yes, I am aware, my lords. I am only trying to impress that probably my.
Aware of it?
I am aware of that, my lords. These are two.
You're
things which
already aware. All right, thank you.
May I, my lords, then request your lordships to permit me to withdraw this and move the Honorable High Court for review, my lords. This finding is completely
Dismissed is withdrawn.
With
Next.
liberty to seek
Do whatever.
appropriate relief.
There's no prohibition against filing it again.
My lord, if your lordship,
Not necessary. Next.
great.
My lords, this matter emanates from the same identical matter which this honorable bench has
Post along issue notice post.
much obliged.
My lords. Matter emanates from the lease and sale agreement that I entered into with the Tamil Nadu Housing Board way back in September 91, my lords. On the condition that after paying 168 installments of 1,405 rupees, I will be the owner of the said property. Subsequent to that, my lords, after a year, in November 92, I took a loan from the respondent for 1,23,000 and I gave possession of the said property to her on the rent of, orally agreed upon rent of.
Validated, right? Subsequently, the allotment is validated.
Yes, my lords.
The agreement of sale is 2002.
Yes.
Sale deed is
2000
2009. No, 1992 is the agreement, November 92.
Yes, the sale deed is.
So he
2000.
becomes the owner
Yes, my
in
lords.
2009.
Yes, my lords.
So therefore, the sale is, you can't say that the agreement of sale is invalid.
My lords, it was particularly that agreement was only, it was a blank sheet of
If
paper
you're
with my
talking about
signatures.
The fact of it, purpose and object, all the courts have held against you.
They have, my lords, but on
What
the,
remains,
they have somehow taken the possession of the receipts with the respondent to be valid claim that the respondent has paid all the installments merely because the installments, the receipts are in the possession of the
that's the only, everything revolves around the question of who paid. And the facts are all courts have held that the payment is made.
My lords,
There's
my
no
only
scope for us to get into this because it's pure finding, it all relies on finding of fact.
yes, but the only finding of
Concurrently
fact
held by all the courts on that. We can't take a different view in the matter. Sorry.
is the only thing that they consider is that the respondent holds all the receipt. The
Good finding.
receipts are in my favor.
Thank you. Dismissed.
Much obliged.
18.
My lord. My lord, High Court, my lord, interferes in a concurrent finding of fact. My lord, without even answering the question of law. Two things, my lord, all the issues, my lord, where the High Court has come to a different conclusion other than the trial court and first appellate court have been answered. Please come to page 21, my lord.
Fine.
All the issues have been answered by the appellate court. For the first time, High Court makes out a case on its own.
Proof is on. They put it on the ground that the burden of proof is on.
Yes,
To prove.
burden of proof, my lord, on all issues. I have discharged. Every finding of the High Court, there is an answer and I have discharged. And High Court, my lord, the first time reappreciate the evidence. 41-31, my lord, assuming against me for a say that 41-31, my lord,
We will
appellate
issue
court-
notice. We will issue notice.
interim order status quo regarding not creating third party interest, my lord.
Status quo.
Obliged.
Obliged.
May it please your lordships.
May I seek a passover? I'm on caveat. Mr. Puvaya is leading me.
Lord, your lordships have interpreted 86(1)(b), both Justice Gavai and then my Lord Justice Narasimha. 86(1)(b) gives the regulator, the commission, all powers to regulate every aspect of power purchase. Commission here holds, I have the jurisdiction and says the premium is bad. The APTEL says commission has no jurisdiction.
Not mentioned in the PPA.
Abhipan?
PPA doesn't mention about it is what.
No, PPA is subject
That's your
to
contention, that
86(1)(b).
there's no such provision in the PPA.
No such provision in the PPA. Amended PPA also, there's no provision. And then the Singareni Collieries charges a premium, which the commission says, I have jurisdiction to regulate the entire electricity sector. If you add a premium, today is adding a premium of 20% and 30%. Tomorrow you can add a premium of 40% or 50%. It will be passed on to the consumer.
But then so far as there's no privity between those, when the Singareni and the generating company, whatever
No, no.
may be the agreement.
Singareni,
But so far
Singareni.
as the appellant
Look,
and STPP are
there is a PPA between Singareni and me.
that we know.
Singareni has another wing.
Correct.
Please, another wing, STTP.
Ah.
It's left hand to right hand, and they charge a premium.
Separate
It's
it.
one balance sheet, and that premium is being charged on me. You can do whatever you like between one wing and another because it's the same balance sheet. Your profit here will be transferred there. You can do what you like. But how can you charge the same premium on a third party procurer, distribution company?
But 21.8 landed cost of fuel is all inclusive of this also.
Yes.
That's a point against
Yes.
you.
No, point
Landed cost.
is, can the commission go into the matter and regulate it under 86(1)(b)? Your lordships have held, Justice Garwai in the first judgment, and your lordship, my Lord Justice Narasimha, in the Himachal case, 86(1)(b) gives extensive regulatory power to go into all aspects of power purchase. So ultimately the consumer's interest. That's what your lordship has said. Ultimately, the consumer's interest is what your lordship has said in paragraph 38. Now, commission says I have jurisdiction, and it says that there is no premium. You are charging a premium on one wing to another wing. How can you charge the premium on discoms? It may be right or wrong.
It becomes a cost for him, no? How do you recollect?
No, it's not a cost for me. He just adds a premium. It is not a cost for him.
Why is it? For
Well,
what reason? For what reason the premium is included?
There's no reason given. I'll show the notification. There's no reason given why the premium. He has a power to notify the price. Under the coal distribution policy, he has a power to notify the price. He has notified the price. And then when it charges me, it adds a premium. Now, there's no reason why the premium should be added. He says, I am charging a premium for all this.
Premium, Mr. Poya, premium is relatable to what?
Although it's called premium.
Catch your breath, catch your breath.
I'm sorry, Melons. I think I'm younger and I'm.
Catch your breath.
Although it's called premium, Melons. Premium is
What reason is relatable to what?
it is related to the colliery control order, which relates to the price of coal that I'm giving them in priority over my regular connections. Well, my coal which is available has linkages. So I have to supply coal to those linkages. This is a captive coal. Now they don't have their captive mine ready. In the interregnum, they want to give me coal. Because I take it away from somebody, I'd give it to them. There is a premium. Not just
that is imposed by how?
That is imposed, my lords, by the Ministry of Power under the colliery control order. Freedom to levy is given to the company.
Where is that?
Not the premium.
My lords, kindly see this. My lords.
Show that it is directly relatable to the ministry's decision.
Yes, my lords. Please see, my lords. Open this.
And why did the commission ignore that then?
My lords, please come to in the impugned order itself, para 47. At page number 32, my lords. Overleaf at 33, your lordships will find, my lords, that very observation. If I can read 47, my lords. Thus from the...
Page 47, para 47.
My lords, para 47, page 33, please, my lords. Thus from the above, it is clear, there, my lords, analyze all the law and the colliery control order. Thus it is clear that post the colliery control order 2000 era, it is coal companies which can fix the price of coal, and the same position is affirmed by the Supreme Court in so and so, so and so. Please see the next line. The coal prices are no longer fixed by the government. However, they are subjected to regulatory oversight of the government. Government retains the power to regulate supply and quantity of coal. The question in the present case is whether...
Where is that instrument document by which it is levied and collected?
87.
Well, it's this.
Where is that levied and collected?
Well, it's in the linkage order.
To become part of the landed cost of fuel. How does it become? That's my question.
Yes, please, my lords.
That's our question.
There are only two linkage order, my lords, which permits this linkage tapering to be given to them. Itself specifies that the price of coal will be determined by the coal company which is being given to them. Your lordships may come, my lords, to 469. Annexure 17 from my lords, kindly see the order is, my lords, by the Ministry of Government of India, Ministry of Coal, 469. Open it. Now please come to my lords, 484. This is the Standing Linkage Committee of the Ministry of Coal. At 485 bottom, please see, my lords, the last line after recommendations, etc. The rate for coal supplied against extended bridge linkage would be decided by Coal India Limited / Singareni Colliery Company Limited. And the same thing is at
Coal
5.
supplies as against extended bridge links.
Yes, my lord. And they are taking coal under a bridge link is admitted.
No, we are talking about, is there any specific reference with respect to the premium part of it?
No, my lords,
There's
that's why.
no
The
word
coal
premium.
price, I'll just, my lords, explain that. The coal price, which is whatever 100 rupees,
Coal price they are paying.
includes the premium, my lords. It's
That's
a,
what it's-
it's
No,
a
no, no.
consolidated price.
Wait us.
My lords, the issue is
Just
this.
that, just that. We are only concerned with the premium, right? We are only concerned. It's not that they are not saying that you.
My lords, in the order,
There is a
please see, my
premium
lords, in the
charge.
impugned
You
order.
may be right, but
Order chart,
you may be right, number one. Number two, whether it is inclusive of the premium.
Where is he noted?
And
Right.
that was
Premium.
identified and looked into by the REC. Show us that.
Please see, my lords, page 46 of the impugned order. Please see, my lords, the premium that is applied by all coal companies on this. Please see 46
Everybody
bottom.
applies.
Yes, my lords. So there is Mahanadi and Coal India, my lords, at 46 bottom.
20%,
Page 46 bottom, my lords. In fact, they apply more than I apply. I'm Singareni, my lords. I'm state also 50%. Therefore, I'm 30%. Coal India applies 40%.
One page.
My lords, please see at the paragraph number 75 bottom. MCL is Manadi Coal Limited, CIL, my lords, prices notified on so and so. Please see the third column, my lords. Premium levied by MCL and CIL at 40% flat. Therefore, my lords, price in the next line. 1240, my lords, is the coal price. 496, my lords, is the premium. Therefore, the sector specific price is 1736. Please see next
So
page, my
therefore, the
lords.
only way you are relating it is that portion which you showed us
No.
just now.
Yes, freedom to determine price, my lords.
Determine price. But then his grievance is about the inclusion of the premium.
Premium. My lords, for a minute.
Therefore, inclusion of the premium part of it, is it? So if the freedom means that you can add anything, then.
No, my lords, not anything.
So therefore, did the REC, just see how did the REC?
My lords, what the REC
ignore
does
it?
is this. What, my lords, I'll just in 2 minutes explain. REC passes an order. What does the APTEL find fault with? REC passes an order saying, you are a coal company.
20%.
You also have a generating station. You are charging a premium on the coal. You should not charge a premium on the coal because the consumers in Andhra Pradesh should not pay more for electricity.
Page number.
Appellate Tribunal, my lords, on a legal point says, coal price is not determined by the REC or under the Electricity Act. Coal price is determined, my lords, by the Government of India under the Colliery Control Order.
To that extent.
And that price, my lords, includes premium by all companies.
That is exactly what we are asking you to identify and show us, that the price will include means on what is the basis for identifying and levying premium. Is it relatable to what the central government does? If it is so, then show us that.
My lords, I'll clarify.
That's the only thing we want.
My lords, there is no instrument under which.
It looks like it seems also to be a general practice for everybody to.
My lords, it's like.
Everybody is levying.
Yes, please see the next page, 47, my lords. In fact, Singareni is levying 30%, where Coal India is levying 40%. Now, my lords, second, may I give this illustration to myself with my lord's leave? My lords, there is railway freight for the coal to move from point A to point B. Tomorrow, my lords, it is like a generating company questioning railway freight, my lords, under an electricity commission. Electricity commission cannot determine railway freight. If railway says, I don't have.
It is like, there's this distinction there. It is the charge which is levied by you on the basis of a central government notification or permission.
Well, central government does not find fault with me.
No, it doesn't. That doesn't matter. But the question is that identifiable somewhere? That freedom, so far as the premium part of it is concerned. On what basis everybody is charging that premium?
The answer, my lords, is this. For linkages to be given, my lords, there is a coal linkage committee, my lords, by the government. Coal linkage committee decides that Sajanpoy will get X tons, Raksha will get Y tons, etc. My lords, that linkage, my lords, is fixed for X number of years. There is a price of coal. Now, because a third party says, my coal block is not ready, give me some, in the interregnum, give me.
That is what we are asking you to.
My lords, that coal
Well,
committee minutes, my lords, are not here.
Where
I
is
can
that?
produce
There's no
that, my lords,
document.
along with an affidavit. That's not here, my lords.
It is asserted that there is no such thing at all. And
May
everybody-
I answer your
even a
lordship's
prison-
question?
Yes.
My lord,
My lord.
he has a power to notify the price. CIL and Singareni and couple of other companies have a monopoly on coal. Keep that in the background. Monopoly on coal. Everybody is dependent on CIL and one or two joint venture companies like Singareni, which is Government of India and Government of Telangana. Now, he has a power to notify the price. I have included in the paper book an example of a notified price. At page 945 is an example of a notified price. Now, that notified price, he enters into an MOU, he fixes it and says, if I must supply coal, I will charge 20% more premium, 30% over the notified price. There's no authority.
That's what we are asking.
There's no authority, number one.
That's what we are asking.
Assuming he
No,
can
maybe,
charge
we don't-
premium, is the commission entitled
only
to
point.
review it?
He says there is no authority for the premium part.
My lords, that is because it's deregulated. My esteemed senior, my lords, knows that fully. Price of fuel, diesel, it is deregulated today, so there is no
So
notification,
he
my
can
lords, from the
charge
ministry.
50%,
No, no,
60% and the commission
Therefore, my
will
lords,
regulate.
when they take coal from me, they are free, and that coal procurement is also approved, my lords, by the commission. They are free not to take coal from me. They are free to wait for their block to be ready and then generate. Because they don't want to keep their generation facility empty, they are taking more expensive coal from me until their block is ready. Today, my lords, and it's permissible under the law for me to charge that 30%. The question, my lords, respectfully is, can the Electricity Commission say that commission is bad? No, the Government of India can say. Have they challenged that 30%, my lords, by virtue of a writ? Answer is no. But in a tariff regulation, an Electricity Commission says the 30% you are levying Singareni because you are a coal company, you should not levy it. Even if you levy it, don't collect it here. My lords, that means coal going to them should go at 30% less. Same coal going to another generator will go at 30% more because that premium.
Anyway.
My lords, it is, my lords. If your lordships, my lords, can kindly look at, my lords, paragraph number 85. My lords, please see 80, my lords. My lords, kindly see 80, my lords, at page number 49. I will just read 3 paragraphs.
Why is it that in the APTEL also they don't really refer? 85?
No, my lords, they deal with it extensively, my lords, from when my lords, pointed out to your lordships para 47. Please see for a minute, my lords, para 43 onwards. They deal with it extensively, my lords, on 44, page number 30. Broad policy regime in coal sector with regard to fixing price of coal. Your lordships will find it at page 30, para 44. My lords, please ignore, they say Pallav refractory, etc. Please straight away, my lords, come to 1 minute. Lords, please come to paragraph number 46 at page number 32.
Charge any price and the commission.
Lords, in 46, please see, my lords, about 5 lines down. Post the colliery control order, coal prices were no longer fixed by the government, but were instead notified by the coal companies and are influenced by the cost of production, transportation, etc., etc. While the Government of India does not exercise control over price fixation, it retains power to regulate supply and quality through coal. So I can't give it to them without a leakage committee. Now let's please see the
Even
next
with
slide.
respect to imposition of the premium, you are not bound. He said you have the freedom to fix it.
Freedom. My lords, I am applying this premium to everybody. That is also a finding in my favor. I do not distinguish it only for this generator. Coal going
And also that not only you, other coal companies are levying.
the larger companies are levying more, my lords. Why do I give less, my lords? Because 50% of Singareni is owned by.
There's no larger company, my lord. It's CIL and Singareni.
It doesn't really matter. It's only you are saying right hand to left hand.
No, Singareni gives it to its own STTP, left hand to right hand. It charges a premium. It can do
Irrespective
what
of
it likes.
that also they can do it, right?
No. The question is, my learned friend is not answering the question. Does the commission have the jurisdiction under 86(1)(b)
That's all right.
to regulate the premium? If he charges a premium, can you regulate it under 86(1)(b)? Your lordships have held in 2 judgments. I'll show the judgment. The judgments hold that the commission's extensive power. Suppose he charges a premium of 100%. Please remember, he's a monopoly.
It seems to be across the board and
No,
applied.
across the
applied
board.
across the board.
It's across the
applied
board is a monopoly. It's a
consistently.
monopoly, CIL.
Please see para 85, my lords.
My lord,
I'm sorry.
let me complete my arguments. I'll have to show the judgments. of Justice Gawai's bench and your lordship's bench.
That's okay, there's no doubt about it. We are clear about it.
The commission has jurisdiction. Now, commission says, I
Question
have
is not of
jurisdiction.
jurisdiction. Question is of the decision.
I beg,
Right.
I'll show the commission's order, my lord, the reasoning and the Aptel's order, which says is you have no jurisdiction. Commission says I have jurisdiction. Aptel says it have no jurisdiction. The question is,
Right, we will issue notice. It's a statutory
question of
appeal.
law is the jurisdiction of the commission.
So only because it's a statutory appeal, we'll examine it in legal.
Please, ma'am.
Issue notice,
ma'am.
issue notice.
It's a monopoly and he can charge 100%.
There's nothing new about it
200%.
being a monopoly. There's nothing new about it, monopoly. That's
No,
the
no.
position all over.
Therefore, there is a commission. Because it's a monopoly, there is a commission. And 86(1)(b) empowers the commission to regulate a monopoly
There we
power.
are. Anyway, take
You know,
notice.
if monopolies are not
I think-
regulated, if monopolies are not regulated, they'll do whatever they like.
Not at all. From 2017, this tariff is approved by the commission.
Fixing up that regulation of
That is
price
because
fixation
3 years
is
you had
different from a regulation of electricity. These are two different things.
I'm grateful.
Anyway, pass. Issue notice. You are issuing notice. Mr. Notice क्या? ठीक है, देखते हैं, examine कर लेते हैं.
May it please, my lord.
Yes.
My lord, concurrent findings that my GPA was without consideration, that the GPA holder has transferred to his own wife at a deflated value only to defeat my interest. A High Court satisfied only on the basis that there was no prayer for cancellation of sale deed against my
Issue
lordship.
notice.
Lordship, status quo as of today.
Status quo.
Lordship, and there's a delay of 58 days in filing the SL.
In refiling?
In filing.
Notice.
Notice on delay, Lordship? Very well, Lord.
We will anyway condone it. But then it should not be condoned with the absence ex parte. Refiling we will condone, but otherwise.
Your lordships, in item 21, I seek for a short passover.
Passover, why? How is this MA maintainable?
Your lordship, the council is engaged in some other court, sir.
Okay, Passover.
My lord, learned ASG is connected.
Similar matters we have granted leave, right? Same order.
Yes, my lord. As per the office report,
Yes. Same order.
identical. Grateful, my lord.
My lords, this is also statutory appeal. I am in a predicament, my lords.
Why, sir?
I was led by Mr. Sibal, but last night, my lords, I was informed he cannot appear in the matter. So I wanted to seek a very short accommodation, my lords. That
I have no problem. I can put in my reply. Your lordships will have it in January, my lords, in the meantime. Nothing's going to happen.
Have we issued notice?
No, first time coming up.
it's a fresh appeal, my lord.
Why?
Oh, my lords, I thought it's because they're pressing
You
for
don't want
stay.
us to dismiss it.
No, all right. Your lordships may have it after, my lords, and I think your lordships will have it in any date, my lords, for my lords' convenience.
Otherwise, it's a statutory appeal, my lords. May
Otherwise, a well-reasoned judgment, my lord, we've been suffering since 2017. Your lordships may have it, my lords,
After vacation.
after vacation. Obliged.
please, I'm up.
That's purely on delay, Manoj. I'm
Hmm.
against the SLP is against an order, Manoj, where my review petition is dismissed on
No,
the
for the
grounds of
defendant, right? It's a partition suit.
defendant. Manoj, defendant in the partition suit, the civil court dismisses the partition suit. It is overturned by the first appellate court. I file a second appeal. My second appeal is dismissed because I did not file an appeal against the first order. Manoj, there was no need to. It was in my favor. I was a defendant there.
But the
Please, Manoj.
the suit was virtually decreed in the first appeal.
No. In
No,
the
first
first
appeal
appeal. So I file an appeal against that, Manoj.
That's your second appeal, huh?
That's the second appeal against the original order. My first appeal because it was overturned. The trial court order was overturned in the first appeal.
Delay.
Manoj,
ये for conduct. ये for dismissing delay पे क्या है second appeal?
Manoj,
Even otherwise. ठीक है, we should notice.
I'm grateful.
Notice.
Grateful. Deeply.
Here also there is a delay, 170 days.
170 days, Manoj. Manoj, this is Agartala, Manoj, and the petitioner has gone.
Partition suit also.
Manoj, the defendant number 5 was his father, Manoj.
After all, what happens and why do you want to knock away the property?
Manoj, I don't want to. I mean, my property is being knocked away, and what's been
It's a
happening is
partition
the
only.
execution is a separate cause of action.
Plaintiff is what to you? Brother.
Plaintiff is not my brother, not related at all, Malaj. I am in possession. So there were two aspects, Malaj. One aspect is that I had bought a portion of the land. The second aspect, Malaj, was that I was in possession, an adverse possession, Malaj. Now the partition suit itself is dismissed by the trial court. In the RFA, he overturns the RFA, the first appellate court overturns the order of the trial court. I am not related to the plaintiffs in any manner.
You wasted your time in filing all sort of reviews. And
Malaj, there was a waste of time, Malaj. There was a waste of time. I should have.
not worth it.
Malaj, that's the only land that I
There
have.
is estoppel
Malaj.
against us.
The defendant number 5, the
Mistake. What is this property? Where is it situated?
it's outside Agartala, Malaj. It's outside Agartala. It's about 100 kilometers from Agartala.
What's the nature of the property?
Udaipur. The nature of the property is agricultural land.
Agricultural land. Okay, notice.
I'm grateful, Malaj. Deeply grateful.
25.
Can a deemed license outlive the rejection of an application for license? Your Lordship held in my favor in the interim stage at page 170. My Lord, application for license was filed. If not replied within 30 days, there is a deemed license. It cannot survive the actual rejection thereafter. After 2 months, it was rejected. Where is the question of a deemed license thereafter? Such a relief has been granted by the single judge and affirmed. Which squarely against your Lordship refused to interfere with the interim order. There was an interim order pending.
447(6) say?
447 says if no response, if the order on an application for any license or permission are not communicated within 30 days after the receipt of the application, as may be, or within such longer period as may be prescribed, the application shall be deemed to have been allowed. The landlord, second. Lord, stay also. Stay. Oblige.
My lord, appeal against the relied upon judgments are pending, my lord.
Correct. Leave grant. Same order.
Public.
My lord, against the arbitral award, the writ was filed before the High Court. The High Court set aside the arbitral award and remanded back to the First Class Council on the ground that on the day of award, the calculation was filed. In fact, my lord, on the day of award, calculation was filed for the interest, up to date interest. Claim was filed in 2010, 13 years back. And the parties have exchanged the affidavit. There was as many as 9 hearings. So finding of the letter of the High Court that on the day of filing the calculation, the award was passed is not correct, Lord.
Award. Arbitration. Let us have a look at that. Why do you say there are no reasons?
My lord, kindly see, my lord, the award at least, my lord. The award at page, my lord, 141.
What big award?
My lord, the award starts at page, my lord, 123. Entire history and the affidavit exchanged, the dates of hearing, all are mentioned. Thereafter, my lord, kindly come to page 141. 141, bottom para, my lord. On 30th July, only
What reasoning you expect in in the grant of an interest? I say.
That's right, my lord. That's what I'm saying. It is only a computation. The rate of interest is statutory. It is flowing from a statute. And the length of delay is not disputed. Only calculation was required to be submitted. That I submitted.
Interest.
And on the request of respondent, kindly see my lord, page 41, bottom para. 141, bottom para.
He's MSME, this fellow? Yeah. Statutory entitlement profile. Still pending whether 226 is maintainable or not.
My lord, in the
refer to a constitution bench.
My lord, my submission is that India Glycol is still binding.
Whether it's maintainable or not.
India Glycol is still binding, Your Lordship. The High Court district wise India Glycol following the Jharkhand Urja.
Mera judgment how this.
In Jharkhand, my lord,
Notice.
my lord, the stay of demand, your lordship, the next hearing before the council is on 17th, your lord.
Stay.
Grateful, my lord.
May I please, your lordship? Lordship, the present order arising from the Honorable High Court Guwahati orders, which declared the petitioner being 59-year-old as foreigners. The petitioner herein has its name recorded in the voter list of 1966, 1970, and 1980.
Omitted essential and most fundamental facts like name of the parents, grandparents,
Lordship,
siblings name, place of birth.
Lordship, in the written
Also,
statement,
High Court says that linkage is nowhere proved between anybody.
Lordship, in the written statement,
Evidence whatsoever.
Lordship, in the written statement at page number 39, the petitioner categorically has mentioned that the name of father of the opposite party has been recorded in electoral rolls of 1966 and 1970 as a regular voter. Subsequent in paragraph number 8 itself, the name of the
certificate was a little exhibit P16. All what happens is that you're producing certificates and not examining, which is a big suspicion about whether those certificates are genuine.
Your
or
Lordship,
not.
it is the admitted
You produce
position.
a certificate, you must examine somebody.
It was not examined, Your Lordship, but the coordinate bench of this honorable court has on multiple occasions.
No, those are different. Each case on its own facts. We
And
have
Lordship,
issued many cases. now.
Lordship, the difficulty is he is 50. In fact, the citizenship of his father, his brother, his sister has not been challenged, Lordship.
But then why is it so? Why, if all the more reason that why is it that you have so bereft of complete facts? Sorry, dismissed.
Lordship, may I take your indulgence, Lordship?
No questions. Next.
She is 60 years old, Lordship. Of life.
29. 29 में letter है. Yes. इसका
Please, my lord. This is a case, my lord.
इसका husband.
Entire family, my lord. I am the head of the family. I came in 1965, my lord. Please, my lord. And status quo, my lord.
Status.
I am grateful.
Wife रहेगा, बच्चे रहेगा.
May I please, your lordship? Lord, just give me a minute, my lord, because a new category is arising for your lordship consideration, which would need a little intervention. So, this order, my lord, it's only the refusal of the physical inspection. I'm coming to that, but there's something which is, my lord, now my lord, I'm obliged to bring it to your lordship's notice. Something, a paradigm shift which has taken place, and the approach has to be different. My lord, now, if a long pending suggestion that the government of clinical material, that is the patient for treatment, they're overflowing. Whatever is minimum needed, they are 5 times. Every bed has 3 to 4 patients, etc. Earlier, there was no collaboration of a private entity with a government college. Now there is a policy shift. It has been permitted. This is one of those cases where the private enterprise is permitted to collaborate with the state hospital. There, my lord, your lordship, I can, my lord, make a very humble submission. Never any issue of clinical material. The number of patients, which is the most important thing for treatment, is never there. Number 2, my lord, most of the changes are being done arbitrarily by various states and various authorities. For your lordships, remember, my lord Mahiduldaar, where time schedule are for two things. One, for your granting permission, one is for admission, and nobody would change it. Here, the states are now changing it on their own, and it has been extended up to 16 December in Jharkhand. And, my lord, now I am told that the applications are coming before the central government. They may come up for further extension because a number of state seats are also lying vacant. They have not been filled up because the permission which should have been done in May have continued till December, the grant of permission. Here in this case, my lord, three cases came up before the Honorable High Court. In 2 cases, the physical inspection which was not carried out by them, which they were obliged to, was ordered to be carried out. And, my lord, I'm told yesterday
that your larger principle will consider, but then today the issue is about interim directions only. That is a different matter.
I'm just highlighting that 3 cases came up before the High Court. In 2, the physical inspections are ordered, and in 1, the High Court has rejected all objections that said permissions I have to grant, but now the time has gone out. I'll wait if there is any time extension. I'm only saying, my lord, your lordship may have it by Thursday. There might be applications coming from the government for extension. There are applications which are coming from the colleges. If, my lord, that happens,
But what happened? Your writ is pending in the High Court.
my lord, my physical inspection is not permitted. Whether I am considered this year, that year, why should I lose on physical inspection? You are chosen and 10 minutes on, say, I virtually inspect.
Problem arises because you are linking every time permission to start a college or
Yes.
near
Yes.
gets linked with
not-
vacancies
Kindly see,
and stray vacancies. That's the problem.
and let me, my lord, I bow down. I am just making how this impractical and arbitrary in this case. Essentiality certificate is to be issued by the state. One of the clause is missing from the format. I had to get it corrected, your lordship. Now, how much time you require to persuade them that you please correct it? It is only that, my lord, on
What
which
do you want today?
I want, my lord, your lordship, just
Have it on Thursday.
permit me a notice Thursday, and my lord, I am praying that if they consider me for inspection, whether I get it this year or not. And inspection means what? Hospital is not to be inspected, which is the most important
Government
consideration. Hospitals are not to be inspected.
But what are the other things on the basis?
Other case, essentiality certificate did not have clause. And the clause is.
Why couldn't you have made all this before the High Court
That's
itself?
not- I did it. I only wanted a physical inspection as the, kindly see 2 pages.
The High Court has not refused it.
No, kindly see page, no, only one thing.
This is just an adjournment order.
Just see
It will
179.
be very unfair for you to even
Kindly
say.
see, 179. That is what I wanted to highlight. Kindly see 179 and 183.
Rest of the merits when High Court
Lord,
has
just see
adjourned the case.
My lord, 179. If your lordship will just give me this indulgence, 179. 2 similar cases which came up at 180 para 7. Physical inspection is ordered, and they are now, my lord, getting a permission only because of the High Court has now granted them that you fully, please see 179 and 180 para 7. It is for the last 3 lines. It is further directed and NMC shall carry out physical inspection. I only wanted that. And 183, second college, physical inspection order.
Man, you are arguing as if High Court has rejected that prayer.
If the prayer for physical inspection is not granted,
Ask them to advance it and then hear it.
therefore I am saying, Lord, kindly have it Thursday. If it is the time is extending, I will go back. If the time is extended, then your lord.
List on Thursday, list on.
My lord, can I serve the other side?
Physical inspection, if it can be done.
It's called the camel and the Arab. You know the story?
No. Lord, it would be easier, my lord, because
Serve.
yes, grateful to you, Lord.
Physical inspection in the month house.
Against adjournment order.
Grateful.
Yes, my lord. We are being led by Mr. Uday Gupta. He is appearing through VC, my lord. We are being led by Mr. Uday Gupta, senior advocate. He is appearing through VC.
Wait, please, your lordship, my lords.
Everybody?
Here, my lords, if your lordship would kindly have page 78 and 79, which is the interim order dated 27 January.
There must be something called integrity of the examination, Uday.
Please, my lords.
Huh?
No, that is there, my lord.
Somebody
All
must
that
have-
the High Court, yes.
You do. How do you want us to relax this position?
No, I am not asking your lordship to relax, my lords.
Semester without passing the first semester?
No, my lord, I am not requesting your lordships to do that.
Then?
All that I am requesting is, my lords, that she was ATKT, which is allowed to keep terms for the first semester. Now, that first semester, my lords, ATKT paper she has given in terms of the interim order of 27 January.
Keep terms.
Lord, ATKT is allowed to keep terms, which is in other ways a compartmental candidate. So she is not a failed candidate, but she's a compartmental candidate in one paper.
But then the
Now,
rule
in
is that the fourth term can't be taken if you don't clear the all in first term.
My lord, that is what I'm respectfully submitting, that at page 78, 79, if your lordship would please come to the interim order, she was allowed to repeat that ATKT paper. The university was heard. Now, all that was simply required was, my lords, the High Court, after this interim order of 27 January, should have just requested the university to declare the result, or at least show it to their lordships, my lords, in the High Court. In case she had cleared the ATKT paper of first semester, my lord, the fourth semester, in any case, she would have passed because she has appeared there. Fifth also she has appeared. Second and third, she has any case cleared, my lords. All that was required was that. And that is why their lordships, my lords, while passing the interim order, said you can appear in your first semester ATKT. Kindly just see the second paragraph at page 78, which is that she submits that in similar circumstances, certain other students have been permitted to appear in the fifth semester examination who were carrying forward their first semester ATKT paper, which, my lords, is correct because the university in its response, written response to the writ petition, at page, my lords,
No, this is the 5th semester, right?
Fifth she has given under the interim order
High
passed by
Court's
the
order,
court.
she was permitted to take the 5th semester.
Yes, so but they did not declare the result. Neither did they declare the result for the 4th semester, nor for the 5th semester, neither for the first
Because
ATKT.
this appearance in the 5th semester was happened because of earlier interim orders.
True.
Then now
No, only one interim order. No earlier
for the
interim
first
order.
time,
Only
they're
one interim
considering
order.
the legality of the taking of the 4th semester without clearing the first. What do you say about that?
Yes, Milord, that is what I'm submitting, that this interim order of 27 January allowed her to appear in that ATKT paper of the first semester. Now, in case, Milord, she has passed that ATKT paper of first semester, which only the university would know. They have not disclosed the result of that ATKT paper. They have not disclosed the result for the 4th semester. They have not disclosed the result of the 5th semester. However, 1 year after this interim order, when the writ petition is heard finally by the High Court, they say,
Bottom
look,
floor, because at the
yes,
time you took the 4th, this is actually a red herring what you are arguing. By the time she had taken the 4th semester, now because of the interim order, you have gone to 5th semester also.
I'm not,
By the
Milord,
time
I'm not.
the 4th semester, did you pass the first?
Milord, first I have given as an ATKT candidate, which is also Milord.
To notice.
I'm grateful, Milord. Milord, could I only request that if your Lordship could have in the reopening week, we'll serve them dusty, Milord.
Yes, the scene edition.
Or reopening week, Milord, so that her 6th semester, in case your Lordships are inclined to, Milord, set aside, then her 1 year will be saved, Milord.
Has she, when exactly did she pass the first semester?
No, Milord, first semester, Milord, she is only failed in one subject.
Where?
That is economics 1.
That is
Now, that
till not known whether she's passed or not.
that is not known. Milord. Had the High Court just asked them to disclose the result,
There is no
things would
doubt
have been
about
very
the
clear.
fact. There is no doubt about the fact that she did not pass it when she took the 4th semester. There is no doubt.
Milord, that is only in the knowledge of the university.
There is no doubt.
No, Milord, I think she has
Because of
passed.
the interim
Milord,
orders, you continued, and now you want to say, anyway, we will issue notice, we'll see.
I am so grateful, Milord, so deeply obliged.
She would have passed.
Because this SLP is arising out of consent order without there being any.
Lottie, terminated. Petition. Advocate. Advocates, no consent, isn't consent saying. Why you are saying a consent order, no? It's a consent order, right?
But Milos, there was no consent.
No consent. That's what you are saying.
The order says us.
बाद में भी बोला नेक्स्ट पेज में नेक्स्ट में बोला अब भाई क्या है इसमें what is even otherwise also what remains the termination occurred in 2019. Your shop was sealed in 2019. What remains now? 2019 the shop is sealed. Fresh tender.
Shop was sealed
You're
in violation of
permitted to
PP
remove
Act.
goods. What's there in this?
There is no provision of sealing in PP Act.
It's all right, but then since when 2019 the shop is closed, take your goods and then move out.
Then the goods, goods were goods were medicines, my lord. All expired.
Then okay, that's okay. Then nothing remains even now. So it was only a permission. But the order was to take it up on 2nd of February 22 and vacate. What happened? You never bought. And then you waited till that date and filed the review petition after 21 days. Infructuous virtually, dismissed. 34.
For the position of the assistant professor, Lord, the university has selected the respondent number 4, who does not have the essential qualification. She has not cleared the net, and her PhD was of 1991. My lord, the petitioner has a very brilliant academic record. He cleared his net twice in 2002, 2003, and he has PhD also. But my lord, respondent number 4,
Litigation.
respondent number 4,
2010 selection, sir.
yes,
You're talking about 2010 selection.
my lord, what happened, my lord? They did not declare the result. And I have stated this fact in,
In the meanwhile, what is it?
my lord, I filed the writ petition.
2010.
My lord, I filed the writ petition. It remained pending. Then I was sent to the chancellor, and
Every
under
stage you lost.
your lordship, kindly see, my lord.
Selection. See, what is
Well,
it?
only
you are
two
expecting
facts
the
are
Supreme
necessary.
Court
My lord,
to do
only
in
two.
this case?
My lord, please.
The selection of 2010 is over. Respondent 4 and 5 were selected.
They were
We
not.
now going to
Kindly
set
see,
aside
my
the
lord.
selections.
The respondent number 4 was, my lord, allowed to join before the interview. It is most arbitrary in manner, my lord. They have, kindly see, my lord, they are joining. The respondent number, the interview was held on 17th November 2010. And the respondent number 4 was allowed to join in August 2010, my lord. The whole selection is vitiated, my lord, by fraud. And this fact.
Too late. Thank you. Dismissed.
Lord, the delay may be condemned.
Delay. Thank you, Mr. Begal.
Please, your lordship. Lordship, by the impugned order, the High Court, my lord, has allowed the revision petition. My lord, by the impugned order,
Only 2 lakh की मामला है.
High Court has allowed
Little
the,
less,
converted, my lord, converted the, my lord,
Just
equity.
2 lakhs, that's all.
No, my lord, what High Court has done in revision petition, my lord, in appellate court, this, my lord, petitioner, he was acquitted, my lord, in 3 cases, and in 1 case, the sentence was reduced from, my lord, 1 year to 3 months. Now, in revision petition, my lord, the complainant went in revision.
Mind you, settle it. It's matter.
I'm willing, my lord, the complainant is
This is a hardly case. The High Court
My lord,
restoring
this
it.
this is reportable judgment which High Court has made. It's, my lord, 401. He can't convert, my lord. Acquitted
There
to
is no
conviction.
conversion. This is completely incorrect. There is no conversion.
I'll read the
Trial
operative
court
portion.
convicted in all.
Restoration,
1 minute.
Trial court judgment.
Restoring only. It is not.
Lord, I read the High Court order.
Listen up.
Lord, I read the High Court order, my lord. He has converted
It
it.
is. He is entitled to restore the trial court's order.
No, my lord, no. I'm due respect, my lord, no. He can send it back to the appellate court by saying he's remanding. Under 4013, he can't convert it, and he has converted it.
Take out notice. We'll issue notice anyway.
And my lord, I am praying for.
Anyway, thinks of.
And I am praying for interim order, my lord. He'll put.
Stay. In the meanwhile, why don't you?
My lord, I am saying that it can be remanded even today. Your lordship may see the legal position. I am not opposing, my lord, that. If appellate court comes to conclusion that yes, he is guilty, he can do it. There is a reportable judgment, two judgment.
Do you want to argue all these cases just for 2 lakhs rupees?
My lord, I have
For
paid him the entire.
13, both of
My
you.
lord, he was my neighbor. I had taken money, we were transactions. I paid him entire money. He had taken my lord, security papers of my plot. He sold it to somebody else.
I'm not going.
I'm not going.
Merits of the matter.
My lord, I'm not going.
If you want both of you settle it and then close it, I think with the good offices of both of you, your party, you can bring peace to the party. Is this a case where these people should fight for so many years? From 2009, they are fighting for just 2 lakhs of rupees.
Indicate that, my lord, we are willing to do it, my lord.
I'll talk to him, my lord. I'll talk to him. I will do it. We'll do it. There's no issue. But he should not be sent to jail now.
You're not. Just settle it. Whatever is there, you just pay and then.
Lordship, I'll
give him some. Give him. Don't get into tell your client not to have ego hassle. Give him something more.
I'll definitely persuade him, my lord. There's no issue.
Else we will restore it, and what will happen? There's no end to it.
Well,
Will we refer it to mediation?
Yes.
My lord, lordship may just give me one chance. On the next date, if you, my lord, without going mediation, we can sort it out.
Notice, Lord Counsel for the petitioner shall take instructions for referring the matter to mediation. List on. Want to take it up on Friday?
My lord,
how long we'll pass it over, call it and then ask him.
My lord, January, your lordship may keep it. There's a marriage in his son.
Even without asking, just we'll pass it over, ask him whether he's interested in settling the matter or you interested in litigation, then we will grant leave and then keep it pending.
As your lordship, please. My lord, only
out.
Lordship.
We'll find out.
I'll find out, my lord. Lordship may keep.
Pass it over.
No, not today, my lord.
All right.
Right.
To vacate.
My lord, I may pray for an interim order, my lord.
We will not issue notice, we will post it after vacation.
Lordship, the interim order, my lord.
In the meanwhile, that he'll take instructions about referring the matter to mediation.
Grateful. Great.
I must, my learned friend is here, I must say that I have no intention, to send him to jail as such.
Notice or stay hoga?
I'll accept notice, for the complaint.
That's why it's okay.
I must say, I have no intention to sending him to jail as such.
You understand? Then all the more reason.
Yes,
All the more reason. This is hard.
My learned senior can use it.
Both of you can sit and then finalize.
Lord, I'll ask him, I'll talk to him, I'll tell him they're definite.
Right.
Great.
Help your clients, both of you.
Great.
Yes.
Your Lordship, this contempt petition was rejected on limitation, and Your Lordship, I agree that we are not good at the point of law here. But Lordship, he is Mali and uneducated person, and this happens all the time in the service matter that a person wins case in the High Court and without contempt and and he does not even know that contempt exists.
Not at all. Thank you. Dismissed. Next.
I'm seeking a short passover with item 37.
I'm appearing for the respondents, my lord, in this matter.
Mr. Sibbal is leading me, my lord.
Yes, Mr. You are the only one who has taken the option of not coming to the court and appearing.
Lord, I'm not actually not well because of this pollution. I'm actually having a lot of cough today.
Stinks your lives. Regional consumers are. What happens to this?
Because I'm seeking a short passover, my lord. Mr.
Passover.
Sibbal is on. Grateful.
He wants a Passover. Is it okay, Venkatesh?
Yes.
Yes, my lord.
Excuse me. Lord, there is one thing I must point out. Your Lordships had indicated him to deposit the amount, but we had made a specific request and Your Lordships in fact had acceded, which is not reflected in the order. That deposit at the rate of 10 from the date of the decree. Lord,
has he done that or not?
He has deposited from the date of 2015.
How much has he deposited?
September 2014.
How much has he deposited?
Lord, the difference comes to about 1,24,000 and odd.
कर लेना, हो जाएगा.
Yes.
Do it. We'll adjourn it. We'll have it after vacation. You deposit the remaining.
Yes.
We'll close it. Huh?
We'll also be requesting for permission to withdraw, so that
we'll do it. We'll dispose it off.
Yes, please.
Let him, because why again?
Yes, I will give the table to him so that he can
deposit that little amount and we'll dispose it off.
Please.
1 minute. Huh?
Your Lordship, I'm requesting for a short passover.
My lord, I'm taking it down.
Yes.
My lords, Mr. Adi Narayan Rao is leading me, my lords. He is not available today, my lords. So he'll be there on Wednesday physically, if my lords may kindly keep it on Wednesday or maybe after.
Hey, everyone is appearing online.
That's my lord. He is, I mean, somewhere else, my lords, appearing. So if it may be after vacation, my lords, he'll be there. Because I don't want him to come, my lords.
Immediately after vacation, my lord, if any short date maybe.
Date is available.
Obliged.
Yes.
Grateful, Lordship.
My lords, I appear for respondent in item 40, my lords. We need little more time to the instructions to take instructions from BCCL, my lords. If my lords will recall, the last occasion my lord had asked us to seek instruction from BCCL.
Oh.
So we'll take a little more time, my lords.
At the request of the learned counsel for the petitioner, respondent, right?
Yes, my lord.
Respondent.
At the request of Mr. Amit Sharma, adjourned by.
My lords, keep it in reopening, my lords. Reopening first week January, my lords.
No difficulty.
3 weeks. 3 weeks.
Grateful.
Grateful, my lords.
May it please, my lords. Lord, I appear in 41.1.
My
lords, this is that forfeiture matter, my lords. Post the LOI for the next 1 year, he does not get the environment clearance to start mining operations. We had taken out a tender for e-auction of a sand mining lease. Was the high
exist? Will the LOI amount to a contract?
Yes, Madam, now
And
Manoj, in Parliament, kindly see these paper in Parliament, this, whatever your lordship put the question on last occasion, put the question before the Parliament and answer. And once lease is executed, then it is contact. Your lordship kindly. Your lordship is right that on that.
what has Parliament got to do? And
Well, in any way,
why are you citing Parliament debates to us?
In any way, on the
What
judgment
is that?
itself, Madam has considered each other.
Shows the LOI.
Malaj, the LOI, it is at page, it starts at page, Malaj, 37.
Power of forfeiture.
Yes, Malaj, it's under Rule 29 of the Uttar
29.1.
Pradesh.
Where is 29.1?
Malaj, 29.1 is reproduced in the impugned order also, Malaj. If you, Malaj, is pleased to see the impugned order at page 3. In para 12,
Forfeiture कर सकता है नहीं कर सकता.
page number 3, Malaj.
Page 2. Page. Page.
Capital
It's a page itself.
Rule 29 is there.
No, forfeiture इसके समय हो सकता है क्या? 27A. 29.1.
29.1, Malaj, page 4.
The successful bidder tenderer after receiving the letter of intent of the concerned e-tender auction, e-tender and e-action shall produce before mining plan and clear environment prescribed as per the rules. So the same will be executed from. So the registration of the said lease deed will be registered in 3 months. The period of lease will be. What is there in this?
Malaj, in our respectful submission, Malaj, 3 months is the time that is given to the highest bidder, the LOI holder, to bring in all the necessary approvals for executing the mining lease deed.
That's right.
Yes, Malaj.
Upon non-compliance, will it entitle you to forfeit is the question.
My lords, may
Yeah, how
please
to
see
get-
the last 3 lines, Malaj.
Just read that.
If due to fault on the part of the leaseholder, registration of the said executed lease deed is not registered within 3 months, then the said lease deed will be treated as null and void and the amount of security will be seized by the district magistrate. That is what we have done. What my learned friend did was, after the respondent, my lords, after the LOI, they got the mining plan approved.
Registration of the said executed. This has not happened, no?
My lords.
If due to fault on the part of the leaseholder, when
Yes,
does
my
it
lords.
become a lease? Then registration of the said executed lease deed.
My lords.
Have these two happened?
No, my lords. The 3-month period is the maximum time period for all necessary approvals. If my lords may see the first part, it is not only for execution. It is obtaining the necessary approvals like mining plan, environment clearance, and execution. All 3, my lords. Otherwise, this will be rendered. Then he can, my lords, then a successful bidder can sit on the mining plan or the environment clearance for years together, and I won't be able to do anything. But that cannot be the intent of the provision. The intent of the provision is you have got 3 months' time to take the necessary approvals.
We'll hear it. We'll hear it.
Very well,
Hear
my lords.
But in this case, your lordship kindly have page 2 of the judgment. Then at few paragraph, all the question has been done. Paragraph 9 kindly see.
In fact, on LOI, my lords, Bhushan is very clear. I'll produce
Not only
those.
Bhushan, but then this is it's not about LOI, it's only forfeiture.
But at 20
Forfeiture is a very strict provision.
Yes, ma'am.
Read the judgment or take the judgment of teleoats.
I'll look at it, ma'am.
Teleoats, you can't. Forfeiture provisions have to be very clearly expressive,
and they are
expressive and strictly to interpret it.
I will look at it.
Teleoats. After vacation for file and disposal.
Grateful,
Notice
ma'am.
gaya hai na? Notice has gone in this, right?
Yes, my lords. Pleadings are complete.
in respect of first installment and release to us, what not. Only Rule 29 is confined. Lordship kindly see the order. Rule 29 is confined.
42. We'll hear you.
Please.
Some date may come.
Grateful, my lords.
Yes. What do we do?
They filed an affidavit day before yesterday, which brings on record certain orders, lordships, as we'd mentioned, as I submitted before your lordships. There was already an ongoing dispute which the District Trade Association has not disclosed before the court. There were orders passed by the High Court, and there are observations in the orders which the High Court says that they filed a petition by suppressing facts, trying to amend the parties therein. So, your lordships, I think your lordships will have to hear it.
My lords, I have some strong objection to this affidavit, my lords. My lord, this matter is
To the application.
to the application which they have filed, my lords, for additional documents. Well, this matter is sub judice before the division bench of the Madurai Court, the Madras High Court, my lords. And now, my lord, this was never the issue. The issue in this petition was only with regard to applicability of Nitya. And secondly, my lords felt that there should be some mechanism for determining the membership. Therefore, the learned amicus had made certain suggestions. We have filed an affidavit accepting all the suggestions and the way forward. But today, all these
No, no,
issues
lord.
cannot be
With
raked
respect-
up,
with
which are
respect,
sub
lord,
judice
I'm-
before the court, my lords.
Yes.
Because
With
these are all
respect,
factual
lordships,
matters.
Ultimately, even if lordships are looking at Nitya and the impugned order in this case, the issue boils down to only one thing. What is going to be the composition of the members and what is going to be their voting rights?
We'll confine to that only.
That's right. My lords,
Yes,
may kindly have
on-
my
on
affidavit.
that
I
aspect,
have
lordships,
said so
my-
specifically because the objection was that there is only 1 year waiting period, my lords, for the new members to be inducted.
We'll hear it.
Then secondly, my lords, because
When do
this,
you want? When do you want?
my lords, as soon as possible, because my entire function has come to a standstill, my lord, because of this. So, my lords,
keep it
any
What, second week of January?
non-miscellaneous.
On a non-miscellaneous
My
day.
lords, at 2 o'clock, if it is possible.
2 o'clock में लगा देना Tuesday खुलने के बाद. Second week Tuesday.
Grateful.
Note कर लो. Note it and then tell me.
Grateful.
Grateful.
Thank you.
Mate, please. My lords, department acts in a diffuse manner, my lords.
Mr. Vikas Shukla. Whatever needs, just compile with respect to submissions and then I make necessary submissions, notes of submissions.
My lords, sir,
We
I
will
kindly request them to give me some advance copy because every
Who?
time on the last minute this paper.
Amicus or?
No. The respondent.
They are bound to. You must supply. You must supply to them.
They gave it on Sunday. Yesterday afternoon they gave
Give them in advance.
Mate, please, my lords. If a department, my lords, acts in a vengeful, vindictive manner, on 3/5/2019, initially an order is passed for not giving me increments for 3 years. I challenge that order before the High Court, my lords. That punishment is set aside, my lords. Then a new charge sheet, new show cause comes into place where I'm not, it's worse than the previous punishment, my lords. I'm suspended from service. Single judge sets aside that order, my lords. Then it comes to the division bench, which is reversed, and now I am before your lordships, my lords. How can I suffer a punishment that is worse than the initial punishment, my lords?
You have issued notice, right?
Your lordships have already issued notice, my lords.
We have filed a counter. Only thing that what has happened.
It's a bit harsh on him.
Lordship, may I just articulate what happened? It may
Then
overall
may I be
look
allowed
very
to argue my
innocuous.
case? May I be allowed to argue my case before my esteemed senior?
We'll put it up for hearing.
Lordship.
List for disposal.
My lords, I am
Lordship,
facing
most
a dire financial.
Lordship may give a short date. I don't have a problem.
I've
But
not
we'll have to
got
argue
any,
it out.
I've not got any
You'll have to
benefit.
set aside the order, right? If you
Lordship, it
succeed,
needs a little argument because I feel
we'll
that
have
it
to
was.
hear them.
Yes.
My lords, that
Prima facie, we are with you, but subject.
Yes.
to
your lordships may
Post
just
for
keep it on a date, my lords, where
Because what has happened is one person.
an early date.
Lordship, at your whatever
Next.
convenient.
if a date can be fixed, my lords, I just.
Yes, we will fix it.
I'm very grateful, my lords. I'm very
It's
grateful.
deeply obliged.
Item 40.
Deeply obliged.
Wait, please, my lords. My lords, the seat in question was a backlog vacancy and the same was reserved for an ST candidate. My lords, the select list to the said backlog vacancy ought to have been drawn as per the Rule 6 of the special recruitment rules that the seat was a backlog vacancy. My lords, the Rule 6 provides a preference to the candidates aged between 29 to 40 years, even if they are lower in merit to the candidate lying outside the said age bracket. Because the selection authority however, draws the select list as per general merit, ignoring the special recruitment rules. Resultantly, my lords, the respondent number 3, who was younger in age but higher in merit, got appointed to the sole post, even though she was outside the said age bracket.
On the 2001 rules to apply.
Yes, my lords.
You've already given a judgment on this point, which has become final now. State of Himachal Pradesh. Check that out.
My lord, in any event,
Service matter, huh?
doesn't apply
Service matter, old rules won't apply.
It's very clear. Even these rules, if my lord just has page 26.
It's covered by the judgment.
The unfilled vacancies are for what was unfilled in 2001. This is a 2016 appointment.
Sorry, dismissed. 45.
This is that the vegetables.
Mr. Agarwala.
Yes, Manoj. Was what I stated on the
What
last
good
occasion
news
is
for
I'm
the other side?
willing to disburse the entire outstanding claims, whatever are the claims.
Lord, the
for 10
total
and a half lakhs.
outstanding loans up to date with interest works out to 12,56,645.
12 lakhs 56,000.
645. It is with interest, Lord.
Willing?
Manoj, we are willing to pay that amount.
Oh, within what time?
Manoj, you may give us 1 month if possible.
1 month, okay. Mr. E.C. Agarwala, Learned Counsel, appearing on behalf of the state of Uttar Pradesh, has at our request taken instruction and has submitted before us that the total outstanding is rupees 12,56,645, including interest. He would further submit that if this amount is paid within a reasonable time, the possession as well as what? Leasehold rights, right? Or ownership right, what is it?
Manoj, this would be
Allotment,
a,
no?
this would be a license, Manoj. This would be a
License, huh?
license.
Possession with the appropriate license
Yes,
shall be granted in favor of the petitioner, full stop. In view of the Mr. Shreyash, to 2 shops with respect.
Only one
46
shop.
and 40, only
Only
one shop.
47.
47.
One is already with you.
No, the 46, what they've done is they auctioned it off. I challenged it
You said you
separately where
gave it.
there's a the matter is pending in the High Court.
47 with respect
47.
to shop number 47.
47, my lord.
Okay, Mr. Shreyas Lalit on instruction says that his client is willing to pay the said amount within a period of 1 month from today.
Yes.
In view of the submission, this appeal is allowed, judgment in order. In view of the above, this is a 32 petitions. In view of the we allow the appeal, set aside the judgment in order passed by the High Court and direct that the license, given license agreement shall be confirmed in favor of the petitioner upon payment of rupees 12,56,645 within, give us a date. Tell us by end of February.
Yes, ma'am.
So and so last date of February 2027. That's a New Year gift he gave you.
Yes, Manoj. I'm very grateful for that.
Thank you, Mr. Agarwal.
Grateful.
With these directions, this special
on behalf of the
civil appeal stands disposed of. 46.
My lords, on behalf of the state, my lords, we will be putting in our reply today. I know we have been a little remiss, but we will be putting it in today.
Okay, at the request of
Last
the
opportunity to
state,
adjourn, but it's okay. That's
filing a counter affidavit adjourned by 4 weeks. List of 4 weeks. That's it. Next.
rejoinder for 2 weeks, my lords. So the lordships may also consider, because they have not challenged the 9-1 order, which is the impugned order, has worked itself out. That is also going to be.
You tell us,
very
we will take.
obliged.
It's a reversing judgment.
Lord, in item 47, I appear for the petition of Lord. Here, the decree was obtained against the person in whose...
We've been litigating from 1959.
It's a reversing judgment.
My lord,
What can be done?
Your lordships have already issued notice. They have not filed any reply so far.
Leave granted.
would my lord may I say this?
we are litigating from 1959.
You settle, in the meanwhile, you want to settle, we'll refer to mediation.
My lord,
But
my
Lord, they
lord
are
may also
actually
indicate a date
completely
on which this
strangers.
case will be
They are
taken.
complete strangers to this litigation.
Sorry?
They are complete strangers to this litigation because I had obtained a decree against the persons in whose favor I have not executed the sale deed. They didn't come in appeal. They have not even challenged that appeal. How can not the appeal court set aside a decree in my favor at the behest of somebody who's having a separate independent right?
Right.
So
If
your
my
lordship,
friend wants to
I
argue,
would
we have
not
no
beseech
problems
your
with it.
lordship.
So my lord is granting leave. All I am saying is let the hearing be expedited. Some date may be
And
fixed.
of course, I will join my friend. I also want not the hearing.
Would my lord indicate a date, my lord? Otherwise, it will not be taken. 10 years is gone, my lord.
Hearing,
We started
Balaji,
at
you know.
59. My lord, I'm
The final hearing, there's no
my
question.
lord. It started in 59, my
He
lord.
said hearing expedited, Balaji. Please, you should
And
just-
my lord may also indicate it's a short matter because there's the rule which says short matters have to be listed at the earliest.
48, 40.
As per office report, my service is yet to complete, Millers. This container may be served through police station, Millers. Yeah, I
You
think,
take possession anyway. Have you taken possession?
no, I have to get the status regarding execution, Millers.
Has he filed an undertaking?
I have to check, but to my understanding, there is a rule they have not supplied us a copy, Millers. But a statement was made before, my lords.
Nobody is appearing. No. We have said that you should take possession. We have already specifically directed.
Office
Pending
report says,
dismissal, we direct so and
Yes,
so
yes.
judge to ensure that the contempt petitioners are put back in possession.
I'll kindly put it after 4 weeks. In the meantime, I'll apprise.
We gave an order in your favor.
Very well, Miller.
What do you mean very well?
But that had not been done as of now.
That's
We have yet to get the
You
status.
have to go and, we said that we can't initiate contempt because they have not filed an undertaking here. So we will dispose it off in terms of our order, get it executed and then get back your possession immediately. We have said specifically.
Yes, may I request, I'll put it after 2 weeks, Miller. In the meantime, I'll get
Just
the
after vacation.
Very well.
Vacation karke mat likhna. Yes.
Obliged, Miller.
I am for the respondent in this matter.
Counter has been filed. I might need to rejoin. Lordship can fix the date. There's that case where Lordship has granted a stay. Habitual absentee.
What is their run?
Well, from 2006 onwards till 2008, she was on leave. Then we tell her to join. She was acquitted. She does not. She says, "No, I want to seek
Lordship, they have
resignation."
Normally in the some heat
But
of
till
movement,
2007, she does not even file a writ petition. From 2011, apparently she makes a request of VRS. Then 2017, she makes a representation and files a writ petition. The writ is allowed on full terms.
Doesn't matter. It is a livelihood employee.
No, that's not how she says. She resigned. She resigned.
That
It
was withdrawn.
accepted.
That was withdrawn.
It was accepted.
May have resigned.
Even Tarsem Singh says, my lord, 3 years. They are relying on Tarsem Singh. It says only 3 years she has not worked for a single day. We'll file a rejoinder to this effect, my lord.
Before it could be accepted, she withdrew it.
No, that's what she says. But it was accepted. Then
You
she
have also
gave me
page
PRS.
79. Have a look.
No,
You
I
have
know.
submitted it.
Lordship will kindly come to after.
Page
Okay, later.
79.
There's a procedure under the rules. Lordship will kindly see.
There is all. That's the man, somebody in a long tenure, she suddenly a heat of
No,
movement resigns.
2006 onwards, she's off. She's not working for a single day from 2006. And look at a conditional acceptance of.
You accepted the.
No, then Lordship will come to page 48, 65, sorry, running page 65, PDF. Now, VRS. Page 67, sorry, PDF 67. After that, she says, give me
Why
VRS.
did you argue for us to issue notice and?
The fact that she never worked for so many years and
From when?
the writ
From
was filed, Lordship will kindly have the date. From 2008, in fact, earlier there was from 2004 to 2006, she was on absent from duty. There was a disciplinary proceedings initiated.
She rendered, when did she join?
In 85.
85
she joined.
85. Girl or a boy?
Girl.
Rinku is.
She's a lady.
Woman.
She's a lady. She's a lady.
88 to 2008.
We worked. 2004. After that, disciplinary proceedings started.
She rendered.
Yes. And what happened
because
was,
of medical leave, Lordship.
on 2008, when she is actually relieved of the charges,
20
we
years.
tell her to join. She says, I want to resign. In 30/7/2008.
She gave her
Resignation.
resignation of 30th of July.
That's right.
And then withdraw.
And
then
withdrew it on 19th of February. This fact you admit at page 79.
But
Then he accepts resignation on 30th March. You
Yes, sir.
accepted after
Resignation. was withdrawn.
after 1.5 months.
the withdrawal was not according
Then
to
he,
procedure, that is our
then
stand.
he, she says that at least give me VRS.
VRS, that's right. And
Then
then
she sent to.
she's not,
Either
VRS also, there has to be a scheme. Now she writes
notice.
that on 9/9/2009.
Sign or release introduce. No.
And my lord, then the representation made in 2011.
Not a case. Sir.
No, but then
I don't
how
think
do I
it's a
pay her the entire back page? Look at the way and High Court.
Whatever you do.
No. Lordship, kindly have the High Court impugned judgment, last paragraph.
Okay, last portion will.
Last portion of the impugned order and read the single judge at page 98-99.
That's not work.
High Court in my appeal also adds 6% interest. She is not worked for a single day.
Light of
Your
this
lordship
case,
hold.
we find no reason to interfere with the final.
That's right. And then, and page 98-99 is a single judge. Lordship will have 98-99 for a minute.
She worked with you for such a long time, Rana. Don't be so unfair to her.
No, one can. No, but a lady who is not willing to work at all. I mean, Tarsim Singh says 3 years. So Tarsim Singh. Yes, Mala. Look at page 98. However, may I read this, Mala? Taking into consideration the fact that the petitioner was in regular service from 85, and it has also been found by this court that acceptance or resignation of the petitioner by letter dated so and so is erroneous based on settled principles of law. Then the direction to pay was directed to release pensionary benefits, gratuity, along with all other admissible
Yes,
benefits.
earlier, actually, you've been unnecessarily. High Court gave more than what we will reverse this against you. It may have been argued.
The impugned judgment. They've added 6%.
Has not been acted, which has been.
But from 2011 to 2017, she does not even report for duty.
So
She can say that I have gone there. Just a minute. She can say I've gone there. They did not allow me to join. She does not do anything 2011 to 2017.
All right. They didn't give back. Thank you.
No, Lordship, can you see this?
No, you're not going to interfere with this.
Lordship, the impugned order for the minute. Last paragraph. They've also added 6%. Now we do not know how to work this out, fellas.
You can easily work it out. No problem.
Here, Malas. Last paragraph, page 35. You have modified the impugned judgment to an order to the effect that appellant shall also pay interest. Now, this is a premium on someone who doesn't want to work. Why should it be out of pocket? And Tarsim Singh, Lordship, last paragraph says
6% is
2008, Lordship will have 2008.
Okay, thank you. Dismissed.
Well, Tarsim Singh
Item
says 3 years, my lord. 3 years.
Nothing.
Very.
50.
I thought 3 years would
Kunal is looking.
Kunal is looking cross at me.
It will be on me because the rejoinder has not been filed.
Thank you.
Thank
you.
Such notice has been issued, counter has also been filed, my lords. The issue, my lords, is whether we fall under the exception, my lords, under section 3, subsection 2, clause.
RERA applies or not.
Applies or not. That's the issue, my lords. The issue, my lords, is there are 13 plots. Our case, my lords, is we've always considered 13 plots, my lords. Now, the issue, my lords, is there are 13 plots. Our case always has been, my lords, that the 13 plots have been separately developed. If the 13 plots have been...
Who are you exactly? You are the...
My lords, I am the builder, my lords. I am the builder.
Why won't RERA not apply?
My lords, if my lords may show section 3, subsection 2, clause A, my lords, it provides that if the area of the land to be developed is less than 500 square meters, or the number of apartments to be developed is less than 8, then the requirement of registration does not apply, my lords. There are a series of 13 plots, my lords. We develop. If 13 is taken into consideration, my lords, it will cross the threshold. If it is taken individually, my lords, it will be within the exception.
Picture of that? You have a photograph somewhere?
Yes, my lords. Lords, you put them on record also, my lords. I'll hand over photographs. Yeah, the photograph.
You have developed it as a common thing, right?
No, my lords. Let me explain what happened, my lords. My lords, I'm a builder based out of Neyveli. The respondents, my lords. Neyveli, my lords, in Tamil Nadu. The respondents, my lords, are lower cadre employees working in the Neyveli Lignite Corporation. They had reached out to me, my lords, asking if they can build plots or provide flats or apartments for them in Chennai, my lords. So I come up with a scheme, my lords, taking into consideration their financial capabilities and constraints, saying that in a plot of 1,540 square feet, I will build 4 apartments. So it was always conceived, my lords, in a small plot, 4 apartments. Others came, others, therefore,
It's a scheme.
no, but let me point, my lords. The point really is, my lords, it was done specifically for them. Idea, my lords, was one single plot of 1,540 square feet, my lords, which is less than the 500 square meters.
How much is square yards? How many square, the land?
My lords, the area, my lords,
You took
1,540 square feet, my lords, which will be 143 square meters.
to build
Let's,
4 flats on each plot.
and 4 flats, my lords. So therefore, both the requirements will fall in.
You took 13 plots.
13, my lord, in fact, what happened, my lords, because they came and said, I need this kind of a requirement, there was a larger plot of land, my lords. I had specifically subdivided those plots. If I was really, my lords, developing one single project, there was no need, in fact, my lords, to actually subdivide the plots. Larger tract of land, I divided the plots, my lords, into 13 separate plots so that I can give them this. I don't just do that, my lords.
We are inclined to take the view that you should come within the regulatory regime of RERA, because it has to be considered as a holistic. It can't be, yes, and it fails imagination to.
My lords, the purpose, my lords, I appreciate what is
thing
falling from my lords.
bits and pieces. You can't cut it into bits and pieces and say they are all individual plots.
No, my lords, in fact, it was actually subdivided, my lords, as separate plots.
250 apartments together.
My lords, it was actually, for them, it was only 52 apartments, my lords.
For them.
Let me just point out, my lords, therefore, it was actually 13 separate plots. It was actually keeping in mind their requirements. Had it been the case, my lords, that I actually wanted to develop a larger real estate project, there was no need, in fact, my lords, to actually subdivide the plots. I don't just do that, my lords. After I subdivide the plots, I actually sell the land to 4 other persons. So therefore, it is taking into consideration their requirement that in a plot of 1,540 square feet, after that, my lords,
I will tell you, you are looking at it from their perspective that they were only a small segment. But the law doesn't do that. What we will look at it is that what is the project that you have undertaken, and yours is a larger project consisting of 13 plots you clubbed together, and you have undertaken a large project. Only they might be owners with respect to only a small segment of it. That doesn't become the reason for excluding from RERA.
my lords, I may just, my lords, draw my lordship's attention to section 3(2)(a) just for a moment, my lords, because it depends upon the area that is being developed.
Prior registration of real estate.
Yes, my lords. If
And
I read out, my lords, 3(2).
Which RERA rules, no? Definition of ongoing project and promotion.
Yes, my lords. I mean, lords, those are other points, my lords. First point is on this, whether I actually fall within the exception. And the question is whether I'll become a promoter, because what happens afterwards, my lords, the land is actually sold to them much before, my lords. In 2012, RERA comes into force, my lords, only in 2017. After 2017, my lords, my role is only actually as they are the owners. There is a construction agreement entered into. I am required to construct. The question, therefore, my lords, is also whether I'll become a promoter. So those are subsidiary issues that come up, my lords. First issue over is, my lords, whether under section 3(2)(a) I fall within the exception or not, my lords. My lords, may I have a look at 3(2)(a)? My lords, I appreciate what is falling from my lords, saying it's a
statute.
My lords, I appreciate, my lords, but this is not something that was done after RERA came into force, my lords.
Concern today, why are you fighting? What's your concern today? It's only one of a project. It's not going to be again for you. It's only a theoretical.
No, my lords, there are other
problem?
implications
What's
that
the
will follow, my
problem?
lords. Once RERA comes in, there are other obligations.
It has to come in.
My lords, which is why, my lords,
RERA
our
has to come
submission
in. It's an act which will protect consumers.
My lords,
and protect you also sometimes.
My lords, I appreciate what is falling, my lords, but my only request, my lords, is the rigors of the law have to be necessarily complied with, my lords. If I'm otherwise falling under the exception under 3(2)(a),
You expect Supreme Court to
My lords,
take you out of law.
no, my lords, my lords,
Then that will not interfere. Thank you.
my lords, may I at least make another submission, my lords, insofar as the promoter is concerned. The question also, my lords, the obligation falls upon a promoter under section 3(1), my lords.
So?
Promoter, my lords, is, if you look at the definition of who is a promoter,
Whatever is the law, will apply.
my lords,
And
the
regular-
submission, my lords, is whether I'll be a promoter, my lords, because these agreements, my lords, are entered into in 2012, my lords. Land is already given to them. They are the owners of the land. Ultimately, what I'm required to do, my lords, after RERA comes into force, is only construction. There are construction agreements that are entered into. Question also, my lords, therefore, whether I'm a promoter, because section 3(1), my lords, places the obligation upon a promoter. They are the owners of the land. I'm required to actually construct now the buildings on that, my lords. So whether the obligation under 3(1), which is on a promoter,
You explain, but then this is only confined to whether the regime applies or not. Nitty-gritty is whatever you say. Thank you. Dismissed.
I'm grateful.
Much obliged, Mayor.
Much obliged.
Please.
Lordships had been kind enough to issue limited notice in the matter, my lord.
Against order to vacate.
My lord, it's in a writ proceeding.
Vacating is something.
Lord, separate proceedings for eviction is.
Those are pending. You will only modify that portion of vacation part of it. Yes, tell us.
But the gym is still continuing, man. Despite our notices, the gym is still continuing to function. I mean, whether he
That you
vacates or not
stop,
is
that you get it stopped. You are running the gym.
Lord, my instruction.
You can't run.
He has got 24 criminal
We are not
cases.
running the gym.
Yes,
That's my
sir.
instruction.
Lord, he is an element who has got 24 criminal cases against him. Very bad man. And he is running it, my lord.
Very bad man.
In violation of.
My Janet senior will confirm that he is running it, man.
Yes, yes, he is running. He is running, my lord. Despite
You are
24.
for, you are for whom?
But I am for the landlord.
Landlord.
Complainant.
Who is the state?
Complainant.
Corporation?
For the corporation.
Stop him. Why are you telling us?
Because it's pending here, but
Go seal it.
He has got no regard.
Go seal it.
pending before this court.
But so far as High Court's direction is concerned, not to be evicted, except according to law. That's it. Isn't
Well,
it?
there is already there is an eviction order in our favor.
That's an interim measure.
There is already an eviction order in our favor, passed by the competent court. Despite that, my lord, he is running. Therefore,
You throw him out, I say, through your legal process, but in a
Correct.
matter relating to a writ petition
Correct.
filed against the gym, you can't evict him.
I understand that, my lord, but
What do you want us to do? Adjourn so that you will take action?
But 136 jurisdiction. But let him not have the benefit of running the gym in violation without any permission, without that. That direction will not be pleased to give.
I sent notices twice, man.
He is running.
See our order, it's very, very clear. We didn't even permit him to run the gym.
But he is doing, that's what we are saying.
Then you stop him, sir. Why are you asking him? You stop him, ask corporation is next to you.
Pending this.
Just seal his gym.
The let me just put that observation, man, because the officers are little tepid because it's pending before this one.
We can dispose it off also. Okay. In continuation of our order dated 18/8/2025, we had, and this is to clarify that we had only directed that directed stay of eviction as per stay of eviction, full stop. However, we make it clear that so far as the running of the gymnasium is concerned, there is no embargo against the corporation for taking action against the respondent.
But this may be disposed of. But we may be given liberty because we already got an order of eviction from the rent controller. But we will work out our remedies there because of the pendency of these murals.
Against the petitioner. Is there any need for us to keep this here pending?
Because rent control proceeding we initiated for eviction order in our favor, he has filed an appeal. That matter could not be taken up because of the pendency. They cite this. Therefore, this may be disposed of, giving us liberty to work out our remedies to evict according to law.
This arose out of a writ petition, right?
Yes.
In which he challenged 10/12/24 order.
Yes.
My order.
Where the notice was issued about sealing of the gym. Leave granted. The specially petition is against arises out of a notice that has been issued on 10th December 2024 to the petitioner herein 10th December by the Assistant Commissioner warning him that the property would be sealed if the petitioner runs a gymnasium without a license, full stop. This order was challenged by the petitioner before in writ proceedings.
WPMD 920.
Single judge dismissed the writ petition. However, while disposing of the writ appeal, the High Court passed the following order. वो quote कर लेना. Para 10, para 9 and 10, 9 and 10 quote कर लेना.
10 Malad.
9 and 10 full stop. While issuing notice
Municipal Corporation Act வந்து நம்ம ஒரு plug பண்ணிக்கலாம். Yes, 10, 12, 24. Eviction order.
Case and directing eviction. Is the appeal pending against that?
Malad.
Is an appeal pending against that?
Rent control appeal is pending, Malad, and separate EP is also.
Also informed that an appeal against the order dated 29/11/2024 is pending. So we make it clear that eviction of the petitioner will be subject to the outcome of the rent control proceedings. Full stop. With this, we'll also, in this view of the matter, the direction in paragraph 10 is set aside. Full stop. We also make it clear that the commissioner will be, the municipal corporation will be entitled to seal the premises in the event running the gymnasium is against the rules and regulations.
Great. In accordance with law only.
Yes, everything is according to law.
Obliged.
Plus, I have filed my counter.
I'm item 52. I'm seeking 1 week's time to file my rejoinder affidavit.
Okay, have it after.
And Mullah, I am filing an application seeking permission to file additional documents. And
we'll have it after some time. Then you file it. You file that up. You have the application been filed or not?
Yeah, no, it's ready. I can give it to him.
Yeah. Additional document already filed.
No, to be. Yeah. This is an application seeking permission to file. Yeah.
Okay, all right. Whatever it is, you file it, whatever it is. Application for additional document is, permission to file additional document is allowed. List after 4 weeks. In the meanwhile, you exchange whatever.
It's only 1 week rejoinder affidavit, 1 week's time may be granted because if it's not in the order, the registry will not accept it.
I mean, rejoinder may be filed within a week's time.
I'm grateful. Can it be a fixed date? Your Lordship is an 89-year-old lady.
We'll give it.
Any fixed date.
Fixed date. Next.
I'm grateful.
Which day?
63, my lords have directed adjournment of similar matter, my lords, to await decision in 24787, my lords.
Lordship, item 53, I'm appearing for the state. We are appearing for the very first time to them, seeking 4 weeks time to file the counter. 53, your Lordship.
My lords have in fact adjourned the, I have no problem, my lords, if they want to file a reply. My lords have in fact said that, my lord.
Why 32?
It's a transfer petition, my lord.
TP?
Please, my lord. My lords, I have adjourned similar transfer petition, same land, my lord. There were 2 landowners who had filed 2 TP, my lord. I have indicated on that day that we will await the decision of that.
Same order.
My lords have said that I will not ask for a reply. Please.
Lordship, liberty may be granted to us to file reply.
Please, ma'am.
Obliged.
May I please your lordship? Lord, pursuant to your lordship's order dated 3rd of November, my lord, permitting me to participate in the counselling, my lord, I approached the state, my lord. The state said that this one seat which was kept reserved pursuant to the single judge's order was immediately filled up, my lord, after the division bench's order. Therefore, my lord, there was, did not permit, the counselling has become, but my lord, here this is a completely illegal, illegal.
All right, we will see. These are all last moment matters. If we can help, we will do it. Otherwise, it's not a case for.
My lord, it's clear infraction of the central government's policy, my lord.
We'll see later. Dismissed.
My lord?
We'll dismiss it now. There is nothing we can do about
Lord, lordship may kindly, my lord, hear me then on merits, my lord.
What do we do at this stage? What
Lord,
relief can we give is what we are saying.
Lordship can give me a admission in a seat can be, my lord, reserved, created.
Where
As your lordship has passed.
Everything is over.
This is totally illegal, absolutely illegal.
Everything is
why
over.
your lordship issued notice.
Can anything be done for him?
Well, it is, the whole petition is infructuous, and the central government has affirmed that what we have done is in accordance with law, and they are not entitled to, under the category of the state, because of the poor medical infrastructure.
Only we can do one thing, we can just see the question of law so that it may not arise a later point of time.
My lord, Lordship may,
You assist us, we'll put. that.
I will, my lord, because this is completely illegal, my lord,
Okay,
and
we'll
by the
examine it.
state, the circular is contrary to the central government's notification.
All right, all right. Okay, list
A
for
short
hearing.
date, my lord, in
List
January.
for hearing. No interim orders, list for hearing. In view of the question of law. Doesn't matter, just adjourn on a final disposal के लिए कहीं date दे देना.
And the ministry also may be directed, man. They are party in this.
You don't make the ministry a party, have you made?
Yes, yes.
Then
They also
serve
have
them,
to.
serve on
They
them.
have been served also.
They may be directed to file a reply.
They are on record, unlike, my lord, what my learned friend says, they are on record before the High Court saying that this circular applies to me.
It doesn't.
Lord, it's a totally illegal action, but your lordship will consider.
He can't sit in judgment over the policy.
Obliged.
My lord has noticed central government also.
We will issue notice has gone, so let them come, they will enter apply.
Very well.
Lordships 55 on seeking a passover, my lords. I'm led by Mr. Devan.
Which one?
Item 55, my lords.
Then would your
That's the
lordship
short
have it
passover.
after the vacation month, after recess?
Contempt.
My lord, this was the matter where your lordships have kept it because the question was this. When
I'm only seeking a short
when
passover.
a transaction is done, no, I'm not arguing it. Lordship was saying, what is it? That's all. When a matter is in violation of an order, whether a court in contempt.
We will list the matter for a disposal.
Please, my lord.
The vacation लगा दें. Next.
Lordships, please.
You can fix a date in this matter?
Yes, we will fix a date.
Lord, this is that contempt in that Calcutta teachers matter.
He's held up.
Yes, Kunal, what is to be done?
Gupta is leading in another court.
What is to be done?
Lordship may pass it over now.
Because I'm appealing for the state.
They have filed an affidavit, my lord.
Vacancies from the state. We have filed.
Because there is a problem, Lord, which I wanted to indicate and I seek some indulgence from your lordship.
What happened? What's the
The difficulty is, my lord, that
56.4.
Filed a counter.
I have filed a counter.
Have you seen it?
I have seen it. The board has filed a short affidavit. Board says we are writing to the government that in this Bengali.
Who is appearing for the government?
because I'm appearing for the government, Lord, the lordship's indulgence.
File a counter. Tell us what exactly is the problem.
Lord, sir, the problem in this case is, Lord, that because of the earlier interim order passed by this court, Lord, large number of vacancies had already been filled up. So now we seek your lordship's permission, Lord, to create a supernumerary post, because unless that is created, Lord, these people cannot be accommodated.
Easily the vacancies.
That may not be right. There are 11,000 posts.
Correct.
Of which there are only 2,800 which are.
Ask your secretary to come. I think they are trying to evade it. Huh?
Yes.
We are getting an impression that you are trying.
Yes.
At page 87 of the.
Avoid. We'll give you the last and final opportunity. We'll list this matter immediately after vacation. In the meanwhile, file an affidavit.
And respondent number 4 is the
don't
second.
do that,
We have filed.
no, I'm saying state.
Respondent number 4.
Lord, the lordship may also observe, Lord, that if need be, we can create supernumerary
You
posts.
do whatever you want. You comply with our order.
But without your lordship's observation, my lord, it
No
will not be
need for an
possible.
order.
They are just
Observation
trying to be
process,
difficult,
huh?
my lord. There is nothing.
There's no need for any observation. If you want to comply with the court's order, it is a legitimate obligation on your part.
In fact, on the
So
last.
an observation will help us, Lord,
Legitimate
in
order. If you need to do it, you do it. What prevents you from?
My lords would recall when the last contempt was filed, my lords had said it was only about reappropriation. They had to
Who is my friend appearing for?
I'm for the original respondent.
He is nobody in the contempt. He is not a party.
I'm the one who's appointed in the interim order.
He is not a party in the
I filed
contempt.
an
order.
letter
These are all
Nobody is
people to
asking
queer
you
the
to do your
pitch.
job.
Will not
They are
accept it.
trouble. Yes, yes.
We will list it in the first week of January.
Correct.
Mr. Dwivedi,
My lord, what is
Yes.
happening is
good that you have come in now. See that. Tell the government to comply with it.
Lord, the government is ready to comply. We just wanted an
Do that.
observation.
There is
Lord.
nothing, no prohibition with respect to what you want to do.
Kindly just indicate, Lord, that if need be, Lord, state may create supernumerary posts for that.
The state shall take such steps as may be necessary for complying with the order of this court dated 4th April 2025.
May I interrupt, my lord? May I interrupt, my lord?
in the meantime, what has
My
happened?
lord,
They have started a fresh
in
process.
an IAS matter, my lord.
Now, not do
My
it.
lord, in another matter.
Don't expand the.
All right, then your
Don't
lordship may
expand
just
this
post it
order.
in the
Just
first
post
week, my
it
lord.
in
Let
the-
us see what happens. Yes. Grateful.
Grateful.
My lord, your lordship may say, failing which he will come.
We will do.
All
The
right.
Dwivedi is there.
All right.
It will be
Carry
done
the
now.
cross.
All right.
With this observation, it will be done.
All right. I take that.
Grateful, my lords. Deeply grateful.
Grateful.
My lords, I appear for respondent number 2. There's a letter circulated.
As per the letter,
I'm seeking time for the counter.
58.
Most
What is
shocking one.
this?
These people are incorrigible, the administration. What happens, Malaj, in the previous year?
This we don't know.
I'll tell you, Lordship. In the year
Who
2000.
is appearing? Who is? This is the
Supporting petition.
Sunit Narang.
I'm not supporting at all.
Stuti Rara.
I'll tell you, Lordship, in a nutshell, Malaj. In 2024 batch, this honorable court, in line with 100 other judgments, said you can't have postgraduate reservations based on residence. There, Malaj, they had 5 years of schooling.
Batch has already come before us.
No, this is that matter. This is that matter. Now, Malaj, what they do.
Lord, may I speak, my lord? If your
Lordship.
lordship
So, Malaj, this is the order part. The matters refer to 3 honorable judges. They said it is covered by a constitution bench and they say no reservation on PG. The administration files an application for clarification, dismissed with costs. Now, in the next year, they again reserve on residence. You should have taken that. And this has been struck down in Vishalta, Kriti, serious judgments. They're incorrigible. And they're back with the same prospect. And the High Court has struck it down.
Now new matters which are getting filed. We have some more fresh matters which have come.
I'm not aware of that. I'm aware of this one.
Here there is one difficulty. Not anywhere.
Well, Lord, may I, with the lordship permission, address I was the petitioner, my lord.
Yes.
Lord, he's just overtaken me completely.
Oh, we didn't see anybody there. I'm sorry, I didn't see.
No difficulty.
Yes, Mr.
My lord,
Tiwari.
the issue is, yes, my lord, the issue is twofold. There are two questions, my lord. Number one, whether quota on the basis of education is by dissent, as the High Court says in paragraph 24, my lord.
Good judgment.
And secondly, my lord, in the 3-judge bench dealing with this very college, your lordships have held that if the seats in the UP pool is, if the 50% seat have to go to the all India quota, they cannot go to the institution.
We have to respond.
There is
Some are not
Lord, the issue of admission will take place tomorrow, my lord. That is why your lordship had given only 3 days. Tomorrow is the date for admission, my lord. Otherwise, this petition will become infructuous, my lord. And then what will happen is ultimately, even if your lordship find that this appropriation towards the institutional preference is wrong, your lordship would be constrained to allow the admissions to go, because that is what happened in Tanvi Bail last year at page 19. Your lordship may kindly see that judgment, my lord. There are two issues, my lord. If the High Court says,
What is the interim measure that you be?
I'm for the student. I'm for the student, Malaj.
Mr. Gupta, may I just address the lordship?
putting a
What is
query.
interim measure?
Answering
Lord,
that.
50%.
Tomorrow we'll pass orders, Mr. Tiwari.
Very well, my lord.
Tomorrow we'll hear. All of you get ready.
Item 59, there is a delay of more than 490 days.
Look, I'm seeking some time.
Which
the
one?
Arguing counsel.
59.
59, there is a delay of more than 490 days, Lordship. 26 years we are struggling. Respondents are more than the age of about 75 years, Lordship. They are already rendered about 28 years of service.
My lord, it's a summary court, summary general court martial proceedings matter, my lord. So it needs to be heard.
Yes, it needs to be heard. Fine. वो तो सुनना पड़ेगा ना?
Yes, my lord.
Is it been admitted?
No, my lord, it's not admitted.
Not admitted, Lordship.
We'll have to admit this.
Lordship,
Final order, yeah. It's against the final judgment. Leave granted.
Directions, my lord, it's listed for directions today. It's listed for directions.
Why?
Lordship, we have.
Why is it listed for directions?
Lordship, we have mentioned this matter because the respondents are more than 75 years of age, and it is 26 years they are struggling in the litigation, Lordship. They have rendered 28 years of service. After 28 years of service, they
Listed in
were
January, my
dismissed
lord,
from
we can
service,
ask.
Lordship.
Immediately after vacations, it may be listed back.
Okay, list on non-listed.
Lordship requesting for fixing the date, Lordship.
Yes, we'll give a date. Give February, maybe then update. So how long will it take?
For me, it will take around 15-20 minutes. I do not know how much they'll
It will
take.
take some.
Because it's very clear in the judgment, Lordship.
Completed of the issue.
My lords may list it after the vacations. My lord.
Partial to conviction and charge. Hearing to lagega.
It will take about a hour for the.
Urgency. What's the urgency is retired and
They are retired in 99, Lordship. Since 99, we are into the litigation, and now our age is more than 75 years of age.
how many of you are here?
Lordship,
Four respondents, my lords.
four respondents.
Hearing expired. Leave granted, hearing expired. List in the month of March.
Much obliged.
We'll do it.
Obliged, Lordship.
May it please your lords. Your lords, I appear for the petitioner in this. My lord, this is infructuous now to that extent because it was going against a disqualification. He has been re-elected.
Yes, correct. That's how it got listed.
Yes.
Dismissed as infructuous.
My lords may kindly record upon instructions.
Upon instruction,
I have allowed to that.
it's submitted.
Deeply obliged, my lords.
Dismissed as infructuous. Thank you.
My lord, subsequent to the election in challenge, 2 more elections have taken place. If today the order of the High Court is upheld or that has to be followed, it will be an infructuous exercise by the prescribed authority.
Actually, everything is also, even the time is also over.
Yes,
now.
so my only submission is that the order of the High Court will be set aside and the situation may be put as it is because there will be no objective, no fruitful purpose will be served by going back to the prescribed authority and telling him to relook into the matter.
We will just say it's become infructuous now.
But my lord, then order of
Notification been issued.
My lord, I am appearing for respondent.
Notification been issued.
No, my lords, this was pertaining to election of 2014. In 2019, another election took place. 24, another election took place. The committee has all changed.
Simply, my lord, my submission in this regard, there is some unanswered legal errors that they are carrying over. So the High Court has only remanded this matter for discretionary to seek to rectify the legal error and to ensure a complete and fair adjudication on the part of competent authority. High Court in exercise of jurisdiction under one. So my lord, the Honorable Court under section 136 of out not to interfere with the non-final recent order, remand order, particularly when High Court found the flaws in the previous authority.
My lord, even on merits also.
So my submission in this, please, my submission in this regard is that, so please dismiss the SLP and allow the fresh adjudication on the matter which is unresolved.
All right.
Unanswered.
Just please wait. Just jumping in and then talking. We didn't even commence the petitioner from hearing.
So my lords, even on merits also, there was a non-compliance of section 25 of the Societies Registration Act. Only one member filed an application before the registrar, who because 1/4 of the total member have to file a complaint or application. Only one,
my lord,
he has also died. In fact, his rights are no longer existing.
My lord, the 25 deals with the election, not with the adjudication of the adjudication, the issue other than election.
I will take care of it.
Very well. That is the only thing. The high order of, because first
not interfere. That's all. Whatever it is, in the meanwhile, if the decision is taken or not taken.
But 2 elections has already been taken place after that.
My lord, but what will happen is that the prescribed authority will go back and have to reinvestigate and everything has to be done. They'll have to call upon the old members.
In the meanwhile, election notification.
Election, etc. 2 times election have taken place and they have not challenged the subsequent elections also.
So then the only way we can say it is that it has become infructuous.
But my lord, then the prescribed authority, the order of the High Court has to be set aside.
What do you say?
Yes, my lord, my submission in this regard is that still there is some issues which has been raised by the
twice. Correct.
So in this case, my submission is that this is
2014 to 19, 19 to 24, 24
we'll
to
just
20.
clarify this. The directions in view of passage of time, we are of the opinion that the directions issued by the High Court, the prayer in the writ petition has become infructuous. You know, the opinion, the prayer in the writ petition has become infructuous. In this view of the matter, the special leave petition need not be interfered with. That suffice.
And my lords may clarify that there is no need for the prescribed authority.
When we said that the prayer in the writ petition has become infructuous.
Lord,
Prayer in the writ
a
petition.
small
as well as
clarification
the-
because they
as well-
My lord, one submission.
yes,
that
directions may
this
be-
doesn't require interference in regard to the through SLP as far as the order of High Court is concerned, because the issue is still unresolved, which leads to be some discovery.
Go for orders are necessary in the petition. With these clarifications, the petition is disposed of.
Very well.
I think all of you are satisfied with this.
All has been. All has been.
Thank you, madam.
32 petition is also infructuous now. Is it not become infructuous now?
I'm 63, madam.
62 is become infructuous because writ petition for Article 32 for not giving reservation on PWD post which was advertised in 2017. It's become infructuous, right? वो कोई है?
Lord, I'm for respondent 1 and 2, the Ministry of Education and Social Justice. The contesting parties would be respondent 5 to 9, the IITs, my lord. And my lord is right, this pertains to an issue many years back.
But then where is the petitioner? Party in person, is it?
Yes. Yes. It was in person.
None appears for the petitioner. In any event of the matter, the issue has become infructuous in view of the fact that this advertisement, that the advertisement in question was issued way back on 14/3/2022. Stop. Next. 63.
May I please, my lord? Lord, this pertains to interpretation of a customs notification. I'll briefly indicate.
What is to be done? We have to hear this.
This has to be heard, my lord. Will not take long.
According to us, my lords, page 10 of the impugned order relies on a tribunal judgment in Patel Engineering. Identical issue, same notification.
No, that would be identical.
It has been
according to
construed in
Tenant.
our favor. Civil appeal filed, dismissed by this court. So according to us, the issue has already been.
And that will be completely different according to us.
I will show from one line in the impugned order itself, my lord. Same issue.
And I'll
same
tell you,
Arya
Lord,
will not easily concede.
My lords,
my lord, I'll tell you, lordships.
not when there is a judgment
Based
in
on-
my favor. On the rare day when there is a judgment in my favor, my lords, I will definitely not concede.
Exemption notice. What is the, anyway, we'll hear you.
Very well.
Want us to, you are all, both of you are ready, then we'll hear.
I am ready, my lord.
We
It will not take long, maximum 1 hour from my side.
have 3 matters to. 1 hour?
Take some time.
Okay, then post after.
And technically, it's not after notice because a delay has not
Notice
been
matter.
condoned yet. There's a
Well, delay need to be condoned so that
We do, it's for us to decide. How much is the delay?
120 days.
120.
plus 110 days refiling.
You can't oppose it.
I'm not, I'm just stating the facts.
Post for disposal. Wait, Tuesday में लगा देना है. Tuesday.
Whenever, my lord, any day.
Disposal नहीं. Wait, Tuesday लगा दे. Next.
Oblige.
Oblige.
MACT gave 16.5. High Court allowed insurance companies. Nobody's appearing?
Yes, my lord, I appear for respondent number 1, insurance company in this case, my lord. One is that there is application for delay and my lord, 465 days delay in filing the
460.
SLP.
It's okay.
Fine. And
They lost
second,
Claim petition dismissed. Okay, admit. Yes. Admit hearing expedited. We'll admit your case.
much. Oblige, my lord.
But this is eviction, my lord. I've been directed, my lord, to be evicted after being in possession for 50 years, my lord, within a period of 6 weeks, my lord. The first appellate court finds fully in my favor, overturning, my lord, and
all reversal, continuous reversals.
Yes, my lord. Therefore, my lord, in fact, the first
tenant,
court
for the tenant.
Licensee.
I know, yes, my lord. I'm a deemed tenant, my lord. I am entitled to protection.
You're still in possession.
We are still in possession.
50
my
years
lord.
from
And,
72
my lord, this entire family, my lord, has literally grown up in this house, my lord.
So what? Don't
Yes, no,
irrelevant.
that's it. That's it.
Irrelevant facts.
No, my lord. The
They are
relevant
grown
facts
or
are
not
these.
grown. What is it?
The relevant facts are these, my lord. My grandfather, my lord, or rather the first petitioner's father-in-law was put in possession, my lord, as a licensee under a license agreement entered in 71 for a period of 11 months. During the tenure of the license agreement, my lord, he passes away. We are allowed, my lord, to continue in possession.
नहीं कुछ भी नहीं है ये कह रहा है कि I have a long uninterrupted possession in 71 complex facts relating to limitation and then the decree was passed without adjudicating tribal issues. Well,
Absolutely.
Your grounds are sufficient to say there is absolutely no case.
No, my lord.
What is it that you have? You tell us some good point. You
I
tell
come
us.
to the point straight away.
What is the best point you have?
The best point I have, my lord, two best points. The first, my lord, is that I am directly covered under one judgment, my lord, which will entitle me to the protection of deemed tenancy. Because if
Deemed tenancy?
Deemed tenancy, that's right. If I continue, my lord, in possession as on 1973, the cutoff date, as, my lord, in the position of a licensee, a person stepping into the shoes of a licensee, I am, my lord, entitled to protection as a deemed tenant under the Act.
Under which Act?
Under the Maharashtra Rent Control Act, my lord. Now, the minute that happens to me, my lord, firstly, I am
subsisting license.
That's
The license is
My
not
brother.
found to be subsisting.
That's I will address that, my lord. That is where I'm covered by a prior decision of this honorable court. In identical facts, my lord, I would submit that where legal heirs, my lord, of a licensee continue in possession, and the first appellate court, my lord, has found that I have continued in permissive possession till 91. They have been accepting rents from me. After that, my lord, after some 18 years, they turn around and say that now I'm going to evict you through a suit.
71 tenancy. Right?
So, firstly, my lord, the first appellate court finds in my favor
When did the tenancy
that I am protected by the law of limitation. Secondly, they say that even on the question of deemed tenancy, you are correct. All of this is brushed aside by the High Court, my lord.
और उसको no license.
Lord, could I just show you the findings of the first appellate?
What do you say about accepting rent on that? On what ground did you lose on that acceptance of rent?
Could I just, in fact, the High Court doesn't deal with that. So if I can just show the appellate court's finding, my lord. Unfortunately, I'll hand it over, my lord. What happened is some pages have been missed out in the type version. Kindly, my lord, permit me to hand it over. So the first appellate court squarely addresses these issues. Your lordship may see, my lord, at page number in your lordship, in what has been handed over to your lordship, my lord.
How is the payment of rent evidenced?
No. I'll just show your findings.
No, it's not an oral payment. It's not by cash.
They did not even
How
pay
did
the
you-
box.
Yes.
How did you pay?
Lord, could I? I'll show you the averment in the plaint. They don't contest that we are paid.
That's not the point.
So I'll be very candid.
There must be clearly the requirement of section 15. 15 is that it must be agreed in writing. Yeah.
Lord,
Clauses. Laws of the license, is it?
Lord, let me put it this way, Lord. My learned senior is correct, my lord, in that we did not adduce evidence before the trial. This is a suit by them, my lord, seeking disposition. The burden is on them to prove that they are entitled.
Suppose they have proved their case, burden shifts on to you.
That's it. Now the trial court, my lord, the first court, does not scrutinize their evidence. And in one paragraph, order says, because their evidence is unchallenged, I am admitting the case.
So it appears that these much of facts are clear. That the license had expired, there is no doubt about it. License period has expired.
Yes.
There is no doubt.
No doubt.
About it.
No doubt.
And that when they filed the eviction suit in 1991,
yes,
the interregnum of 1971 to 1991,
yes,
in that period,
yes,
you say that there is a continuation of the license because of the acceptance of rents.
And that is the
But
finding.
so far as acceptance of rents is concerned, there is no evidence.
But that is the finding of the court, my lord. I'll show you, lordship, how that
court
happens.
is-
And it is also pleading in the plaint. They cannot argue contrary to that pleading. Your Lordship may see para 8 of the plaint.
Reason
Yes,
that there is no evidence to that effect. So then what?
No.
The High Court is not wrong. High Court, suppose it had reappreciated the evidence, it's a different matter.
My Lord, your Lordships have
It's a difficult case and you leave it at that. How much time you want to vacate? Tell us.
Lord, as I mentioned, my Lord, we've been in possession for 50 years.
How much? He is very liberal to grant time. Tell us.
Always leave it to the court.
Tell us.
Always leave it to the court.
Consider 2 years. I would be very grateful, my Lord.
Subject. Ab बताइए.
Nowadays, what goes on, your lordships are aware.
So,
The minimum
you
period.
people don't vacate. That's the problem.
If your Lordship state, my Lord, we will
You don't vacate and then we will issue contempt notices and all sorts of things will happen.
Lord, the first petitioner here, my Lord, is she's not a good lawyer.
6 months, 6 months, 1 year.
She's around. Lord, the family, my Lord, has more or less. So it is a.
Tell us.
That's too high. That's too high a period. Nowadays, all 3 months, 6
The
months.
first petitioner is a widow, my Lord. Her children are dependent partly on, my Lord.
Subject to all of you filing an undertaking. And we will also make a part of our order that after 2 years, after the expiry of 1 year, they will enter and take possession and with the assistance of police. There is no need for us to ask for any contempt petition. No. 1 year. 1 year.
And 1 year.
You have to give an undertaking.
Yeah, that's what I'm saying. Is there ready to go to
If your Lordship require an undertaking, Lord, could I request that you have it on Friday? We have an affidavit filed.
Okay, all right. Put it on Friday.
Please.
But we have concluded the arguments. Huh? You just have to only address on the undertaking.
Could consider 2 years.
You better also, you can advise your client not to pursue this. They will have to execute it. In execution, you will have a whole life of 5 years. Who knows? Who knows how in our country.
Undertaking is better, my lords.
It's up to you. Put it up on Friday.
Lord, may I only request
I just understand this actually the terms of the undertaking so that I can.
Undertaking is a standard format that you will hand over peaceful possession, clear all rents, hand over possession and file an undertaking within 4 weeks or 5 weeks. If that is not done, automatically they will be entitled to evict you. And 1 year time will grant you. There is no big science here. Sorry?
Payment of arrears within 4-5 weeks may be a little difficult.
Take more. Arrears, I don't think is not much of an issue. We'll give you 3 months for arrears, 4 months or whatever it is.
I will take instructions.
They are bothered about possession.
If your Lordship may grant till Friday,
Now Friday we'll go to
Only request is instead of Friday, maybe I have it on Thursday, if possible.
Thursday.
Please.
Come on Thursday. Thursday.
If it may please your lordship, senior advocate Rahuf Rahim is leading us, my lords. He's in court 3 on his legs, my lords. May kindly pass it over, my lords.
Come tomorrow.
Lords,
We'll post it along with that.
In that, my lords, that is only on the basis of domicile.
Take it up along with that tomorrow.
All right, my lords. Highly obliged, my lords.
Post along with that. The state's item था वो अभी कल के लिए लगाया था ना 50
Item 58 was, my lords. Chandigarh Union Territory.
The state has also filed an SLP in support. We are both add item. May list that also tomorrow.
Yeah, give the number.
We'll give the number.
From the caveat, your lordship, I have not received the copy. I'm the original writ petition.
Take it.
No,
Take care.
they are on caveat. You may.
I have already served you.
Sir, please don't. Small issue.
Well, I will again do it.
Controversy on that.
Yes, sir.
Deeply good.
Highly obliged.
council is there.
Not taking application. This which year is this?
We made application, my lord. We deposited
First time is it?
money was also there.
No. This application you made for starting BFA.
No, it's only for renewal, my lord. New course, my lord. Some other course we wanted that we rejected. We are not agreed by that.
1 year course is it?
Existing course, my lord. Existing course.
1 year course is it? These are 1 year courses?
No.
B Farm.
2 year and 4 year. Diploma is the 2 year.
3 years and 4 years.
The 4 year.
Have you already got a diploma?
Yes.
So you already admitted students of
Yes,
how many years?
2018 onwards we have been doing. 2019 onwards we have been doing.
Is it?
No. This institute is going on, my lord, since 2019.
Why should there be a small break because of?
No. We written 7 times to file the SIA, fill the SIA. 7 times. I can give the dates.
It doesn't matter, some mistake would have occurred.
No, it's not.
They will not close
no.
their own college for just because
No.
some amount of
And
is tried to be deposited belatedly.
No, my lord, entire session has gone. Last cut-off date was the 31st of August for granting approval. For compliances and appeal for 30th of September.
When did he present? When was the last date, tell us?
And last date was the 30th of September, my lord. For some colleges, my lords have extended
30th
till
September?
Yes, last date for granting approval.
2025.
Yes, for the academic
And he
session
applied
25-26.
earlier.
No.
1 minute. He filed a writ petition.
Just 1 minute.
For grant of renewal for the academic year 2025. And the High Court's direction is to consider their representation on 9th of September. And he submitted a DD of 3,54,000 along with a certified copy of the order.
Just
they have rejected it on the ground that the time is over.
Just see page 136.
Yes, time is over for the academic. But has he admitted students?
No.
Counseling and everything
For
is over.
No. My lord, for academic session 25-26, they did not admitted any student. The running courses are there. We are not going to disturb running courses. Suppose second year
26, we are asking what is happening.
No, this college has not allotted any student.
Oh, then students
That
are
counseling is over.
Students are not allotted.
This year, for matter
Next
20.
year, of course, you will get it.
They applied for bachelor and diploma. We will grant.
But every year, we have to seek permission, seek extension. This year we applied for. Our money, kindly see, we deposited.
Today, what do you want? The students are also not allotted to you.
They will be allotted because
No, it can't be
there is
done
a
now.
huge demand for that. There is a huge
Won't be
demand.
done now.
There,
Won't be done.
in a similar matter, you will also extend it. It is because of
When
that
was
you
the
will
last
please
date?
to issue notice.
Last
Lordship,
date of
kindly see.
counseling was the 31st of
Your Lordship,
October
kindly see
2025.
Your Lordship's order, my lords. But in a similar matter, after having seen this only, your Lordship,
We
please
thought
issue
you had
notice.
admitted, Nagmuthu. Students are there, so we didn't want that sacrifice to happen.
You Lordship, kindly see, 3 years course and 4 year course, the students are already studying. Otherwise, for the first year, if there is no
We are
student,
not going to disturb the running
if there is no
courses,
student in the
second year,
first year,
third year and fourth
then
year.
the staff members are to be sent out, and it will be difficult. The staff strength, we will be paying salary.
All this will depend upon whether, even if we interfere, whether you can take in students. There are no students allocated to you.
But it is because, it is pending with them. Students who have not been allocated, they will be allocated.
Over the council.
Yes,
Yes, Murad.
Pharmacy council.
Ratma, can you see in a similar?
Can they take now, allocate students?
No.
And then take it.
Entire counseling is over. And
But
counselings
not-
are conducted by the state,
not
not
by
by
the
the
Murad.
council.
Entire counseling is over.
Yes.
Stray rounds are also over.
Yes, all, each and everything.
Everything is over.
Yes.
They cannot do, they are not the authority who are allotting. It is the state selection committee. State selection committee has got no objection. State selection
Then why have you not served on the state every time you take?
I have served on.
Where are they? Who? Where is she?
We served her.
What
I
time?
informed her also. She's not here.
Pass over, bring her.
Yes,
bring her.
but I will bring her.
Bring her.
Great.
May I please, your lordship. This is a matter with regard to that octroi, my lords, wherein there is an arbitration arising out of the 1940 Act. There was an award in my favor. This needs.
Sorry for the.
No problem, lords. Can it be had on a Tuesday, my lords? Because quite a few line of decisions on this point.
Nothing we we will take care of it.
Lord, can we have it, my lord, after vacation?
Is it all right with you?
Very well, my lords.
Why
Immediate
after
first.
vacation?
Oh, no problem. Yes.
And therefore, my lord,
What color for it? It's so wrong. Okay. Come back. This man is traveling somewhere.
Very well, your lordship.
Have it on immediately after the opening.
please do.
Dictate कर लो सर.
Tuesday, चलता रहेगा. आने recess, finish it.
week. Second or third week of January.
Very
Third week में Friday, Tuesday में लगा देना. Third week of January, Tuesday.
Please, Milord.
obliged.
The respondent in the first matter and the petitioner in the second matter.
Lordship, I am appearing for the petitioner in the first matter, Milord. Item number 69.
Yes, yes. 69.
Please, your Lordship. My Lord, I am for the petitioner in item 69, Milord.
Yes, yes.
I beg to appear virtually, Milord.
Yeah, tell us. We will hear you. We'll just.
It can be heard to me. This was act matter which was.
Tell us. That's discharge now. We'll hear you.
Yes.
Yeah, my lord, may fix some fixed time or some.
No, tell us. We are ready to hear you.
No, not today, my lord, because the senior counsel appears in this matter.
Senior counsel appearing.
Milord, I am ready, Milord.
You're for the?
I am for the petitioner in the first matter, Milord.
Please,
If your
petitioner.
Lordship.
Okay.
What's the problem?
No. You may continue.
You tell us. We'll hear it.
Very well.
May I continue, Milord?
Yes, you continue.
My Lord. May it please your Lordship. Lord, my section 11 application, Lord, was rejected.
Before my learned friend,
By
just
the-
point out one aspect. The second matter is dependent on the first matter. If my learned friend wants to start, I have no difficulty. In the second matter, rather the first matter is passed on the basis of the judgment in the second matter. If my learned friend wants to start, I have no difficulty.
That's right. That's right. Why? How come two different counsels?
No, I am appearing in the second matter for the petitioner.
Cross SLP.
My lords, I'll just.
These are arising out of section 11.
That's right. So
Section 8 rejected by the trial court.
That order is set
First
aside by
appellate
the-
court also dismissed it.
So I have
I-
challenged that section 8 order.
Correct.
So therefore,
that you succeeded before the High Court.
No, in the section 8 proceedings, I have failed before the High Court. So I have filed the second SLP. The section 11 order is passed on the basis of the before I had failed. I mean, before.
You know that.
So therefore, I'm just pointing out the second matter might need to be taken up. Thing. If my learned friend wants to start, I have no objection. But perhaps.
But there are two different counsels appearing for them.
I don't know, Malud. For them.
How come there are two?
No, my lord. We are because I had instruction. He may fix a date. Otherwise, he may continue, my lord. I have the same counsel.
I am ready with the matter, Milord.
No, that's all right. We can go on. I'm just saying the second matter might need to be taken up first, is what I'm saying.
You start the second matter.
May I indicate only one thing, Milord. My section 11 application was, Milord, rejected without going into the merit of the matter. Milord, it was rejected only because of the fact that the finding of section 8 code.
Okay, you get ready because we don't want to bits and pieces. If not already.
Milord.
You argue it. We will have it on the second week of January on the Tuesday. Date de dena. Tuesday, second week of January. Date de dena. We'll give the fixed date for you.
Very well.
Deeply obliged.
I'm sorry, I was only pointing out that the
Next matter will be solved.
Grateful.
1 minute.
Yes.
Second week of February, January कौन सा date हुआ?
That's okay. No?
वोट खोले miscellaneous के बाद first week में. करेंगे नहीं.
Compilation is filed 24.
13th of January, my lord.
We have filed a compilation and a written submissions this way.
Ours is also on record.
Grateful.
Milord, I may be excused for bad throat.
Oh.
I may be excused, Milord. Milord, on the last date of.
Give you a date in there?
No, Milord. I'm ready, Milord.
We thought you were asking for time.
No. I may be excused for the bad throat. That's.
No, issue.
Milord, on the last date of hearing, this argument was advanced by Mr. Dusan Dave, Senior Counsel.
Who?
Mr. Dusan Dave on the last date of hearing. When the
item?
70, Milord.
Ah.
My lord, this case is squarely covered by Cox and Kings versus SAP India Private Limited, my lord. My lord, if you go to the order, my lord, paper book of SLP number 19853 of 2024.
Yes.
My lord, I would like to go take you through the impugned order, my lord.
Shall we come back after lunch? We'll come back after lunch.
As you wish, my lord.
We'll come back. It's already 1. Wow. You're all ready or?
Yes, yes, but it's a very short matter.
We'll just finish the miscellaneous and then.
Very well.
सुन लेंगे उसको. नहीं?
Come on, yeah, what the hell? Last order. Well, this is coming after notice, a batch of cases.
What is
which
this?
we'd asked your lordships to look at one aspect, my lord. This is
No,
with
what is
reference-
all this? What are all these batch matters about?
There's a final judgment of your lordships. We have filed SLPs because we had gone to the High Court saying that a bunch of us had to be considered. We were in the merit list. We were fully within the chapeau of consideration. Unfortunately, when the earlier matter came to the Supreme Court, there is this number of 906. If I can just hand this up, it'll explain in half a minute what the issue is about. Lordships have issued notice. Give one to the other.
What should it be posted? It's coming after notice. So what is?
It's coming after notice. We'll take it another day.
What is to be done?
So
Must be
in
heard.
another day, yes.
Must be heard, Raj.
About 10-15 minutes from our side.
I would just take lordships to a judgment which has been passed by this honorable court where the issue
Give us
is
the
already
citation.
decided.
No, it's on record. madam.
Lordships, this is.
It's Anupal Singh. It's at page
passing
220. It's at page 226. We have placed it. I'll just explain what the issue is in a minute. No?
We'll take it up. If both of you are agreeable and ready, we'll dispose it up.
No, take it up now.
Tuesday.
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 Very well. Tuesday will.
In this matter, who are similarly situated applicants.
We will see, sir. We will see at that time when they hear.
Very well.
Basically, the prayer is for what?
That they should be observed, the 906.
Adoption.
Lordship said, I believe, told the state to take instructions if they can be absorbed. I don't know.
In fact, lordships, one of them, Kaushal in there, there's a second advertisement, a fresh advertisement.
What
He has already.
What Shailesh is saying, is there a possibility for them to be accommodated?
No, lordships, at this stage.
No.
It would not be.
Then
Though
Tuesday,
they've
your lordship.
been given that
hear
opportunity,
you.
that indulgence, lordships, to take part in the fresh advertisement, which one of them in fact has.
Then we'll hear you.
Yes, Lord.
Very well.
So Tuesday लगा देना आगे वाला.
Could it be a little high on board because the advertisement is issued? Now, if they fill up all these vacancies, my lords, then
This which
In fact,
state of
written
UP.
examination has
state of
been-
UP,
State
in
of
spite of having succeeded in the exam, will be out.
The written examination has already taken place.
And
Some early date.
document verification is also
I
on.
mean, these are people who are working with you.
No.
We succeeded. We were in the select list.
Oh, select list candidates in the.
We are meritorious candidates. In our view, our selection is covered by your judgment. Unfortunately, after the judgment, when they had to implement it, they excluded us. We went to the High Court. High Court held against us, saying your lordship's judgment should be covering it, even though explicitly it does not.
Short
It's a short issue. It's about a revision of numbers, basically, whether we're out or in.
Your Lordship, my application is also pending for impediment in this matter. I am
Tuesday, Friday लगा दो.
Yeah. No,
The following Friday.
by Tuesday.
Any process they undertake should be subject to the outcome, my lord.
Our order will be final.
That's-
We-
Lordships, the advertisement is of 2024.
No, my lord.
The process has already started.
Friday के
They
लिए.
have been hanging
Friday.
since 2000.
Your Lordship, I am appealing for 30 of the candidates, 30 of the selected candidates, Your Lordship, out of
Only
906.
week left, no?
70.
This Friday.
Friday.
This Friday.
Your Lordship,
Not this Friday. Immediately after the court reopens.
Okay, court reopen.
Your Lordship, consider having it on Tuesday.
No, it's a
Very
miscellaneous
important.
week. First week is miscellaneous.
Heavy, very heavy. And 20, 50,
The
60
lordships
matters
is
every day.
on the reopening. On the reopening, grateful.
Yes.
if I may submit, Your Lordship, and
I'm
item
sorry,
71.
could it be second Tuesday of January? Because I'm not sure if on a miscellaneous day we'd be able to.
Second Tuesday.
Second Tuesday of January. I'm
Your
great.
Lordship, if I may submit in item 71, Your Lordship.
Yes,
Second Friday लगा दो.
Please.
Friday.
Second Friday.
Obliged, Lordship.
Your Lordship, if I may submit in item 71.
We've given a date in that.
Your Lordship, my implement application is there, Your Lordship. I am
We'll see
appealing
on
for
that date.
30
We'll
of
see
the.
on that date.
All right.
Yes, now because in 72, just to simplify the point, because they've now filed their counter affidavit. We're giving this, no? Okay. Yeah, but sorry, I'm in the second matter.
R1.
We just.
I beg to appear for the respondents, my.
Yeah, I'll just.
What are you saying?
No, we'll just. I'll just finish it off to 2.5 pages and whatever your lordship decides. I'll just tell you the background. The background is.
Riverine and.
That's right. That's the background. Now the other side has filed a counter affidavit, though a little late, but that's all right. Now they have focused on one issue, and essentially their point is that look, we are not going to look at the experience of the second joint or the junior joint venture partner. Just please note that. So I am in a joint venture. The bid was put in by a joint venture. The lead joint venture was Dharti Dredging. Please just note Dharti. My learned friend appears.
I appear, my lords.
In Dharti Dredging, 51%. I am Sahara Dredging. I am 49%. Their point is that our tender conditions are such that the experience with regard to dredging of a marine type situation must apply and is required to apply only to the lead joint venture partner. So it could apply to Dharti.
Dharti is lead.
Dharti doesn't have it. And we are not going to look at the experience as far as Sahara is concerned. All right. So, my lord, now with this background, that's the narrow issue. My learned friend will, of course, address your lordship separately. Now, my lords, I am in the, sorry.
So the matter will go on now.
Yeah, we'll just.
My lords, I am assisting your lordship.
Yes, 10 minutes.
No issue.
15 minutes. Yes. Now, my lords, may I request your lordships to take up the Sahara paper book?
You wanted
So I'll
to read
just
this.
go to the clauses because my.
You wanted to read this.
I can read it, but I'll just show the clause. I'll just keep that and I'll read it immediately after pointing out the clause. Sorry? Yes, if your lordship is pleased to go to the tender. Just a minute. It's what? My lord, it's annexure in the Sahara SLP, which is, I think, the second matter, 72.1. My lord, annexure P6 at page 148. It is where the document begins. 148, annexure P6. Your lordships have P6. Please directly go to 163. 163, your lordship has.
Wait a minute, my brother has to take.
Justice Chandurkar has it?
Yes, he's taking 1 minute.
Okay.
Yes.
Your lordship has it. May I request you to go to page 163, please? You will find clause 3.6 there. Your lordship has it. So PQ stands for pre-qualification, come technical qualification criteria and evaluation procedure. 3.6, correct? Please go to the foot of that, towards the foot of that page, 163. You will find experience criteria. Your lordship has that. Please mark it. Similar works successfully completed during the last 7 years from 2018-19 to till the last date of online bid submission. At least one similar work of estimated value that is not less than 24 crores 83 lakhs 50,916. Details of it to be executed. Now, please see, this is important. Definition of similar work. So, this is one important feature for our case. Similar works means successfully completed dredging works of value specified above either capital and or maintenance in nature, in marine condition, including disposal of dredged soil in deep sea using suitable dredge spread. Your lordship has that. So this is where the notion of marine condition comes in. So this is one thing to be marked. Now please see last line on page 164, clause 3.7. Bid by joint venture / consortium. Your lordship has that. 3.7. So that's the heading. Just go over to 165. 2 or more bids, but not more than 3, may form a joint venture amongst themselves or by including some other firms having required expertise / experience and submit the offer in the name of the joint venture company, Form 4. Your lordship has noticed that. So please see this. The whole notion of a joint venture is that you can, in this clause at least, is that you can combine your expertise and experience. Very clear. Otherwise, why have a joint venture? Now, please see, there are sub clauses. Bids submitted by joint venture of 2 or more firms, but not more than 3 as partners, shall comply with the following requirements. Then there is A. With your permission, my lords, I'm skipping A, but I'll read it otherwise. The bid, as in the case of a successful bid, the form of agreement shall be signed by the lead partner notified in the joint venture agreement or by all joint venture partners so as to be legally binding on all partners. Now, B is of some significance to me. I'll just place it. A member of a joint venture firm shall not be permitted to participate either in individual capacity or as a member of another joint venture firm in the same bid. So this is one concept, first sentence. Now there's another concept. Similarly, no bidder shall participate in any consortium member in more than a bidding consortium for this work. Your Lordship has that. So now you have just, I'll just come to it, but just see in 3.7, which is the last line on page 164, they use the expression joint venture and consortium separately. Here also in subclause B, they have 2 separate concepts. They have a first requirement that if you are a joint venture firm, then I am a joint venture firm. Then you can't be a member of another joint venture. And similarly, then they have a separate sentence and say, because a consortium is a more loose arrangement, may not be in the form of a firm, etc. There also you can't be a member of 2 consortiums. Now this is there. Now we come to the clause which is the focus both ways, which is subclause K. K. So please see K, which is at the foot of page 165. I might indicate, I'll read it. They seem to refer to the earlier part, I refer to the later part. Now just have a look at K. Your Lordship has it? Justice Narasimha. I'll place it. In case of consortium, lead partner must have 51% of minimum experience of similar work as in the clause minimum pre-qualification criteria and evaluation procedure, i.e., if the bid from joint venture bidder are acceptable, the figures for each of the partners of a joint venture shall be added together to determine the bidder's compliance with the minimum qualifying criteria. One complete work shall be considered towards qualification. Your Lordship has it. Now I make 2 or 3 points and then I'll be done.
Joint venture, consortium. If the bidder from joint venture bidders are acceptable, the figure from each of the shall be
So
added.
can I just place the point? I'll place his point and at least my understanding of that. See the first sentence in K.
So you got the point.
Yeah. In case of consortium, there is a 51%. For joint venture, now they themselves make that distinction and they say everything will be considered together. Now I am a joint venture. So I am simply saying that, look, this requirement, assuming it applies to a consortium of 51% minimum experience of the lead partner, doesn't apply to me.
All right, what did the High Court say?
The High Court, just similar, there's a 3-page order in the High Court. They just said that I'm disqualified and they've accepted their stand because there was no marine experience.
Why did they disqualify you?
No marine experience. Just see this. Para 2. I'll just read 2 paras. Para 2, page 1. The brief facts of the case are that the petitioner is a joint venture comprising Dharti and Sahara. The respondent Gujarat Maritime Board floated a tender dated 1st March 2025 inviting tenders with a e-notice and tender number so and so. The petitioner had participated in the same. The respondent's with a email dated 13th May 2025 had informed the petitioner regarding its disqualification in tender process and consequently the petitioner's bid was not selected during the evaluation process at the pre-qualification stage.
Page 4, page 4.
Page 4. Now please see straight away. Number 7. So para 7, your Lordship will cite, read that definition of site. Site means the land, seabed and other places on, under or through which the works are to be executed by the Gujarat Maritime Board. Then experience criteria is indicated. That I had read to the court, a definition of similar work.
They have gone on something else altogether.
Yes, so they have gone. So this is so please see para 9. They have gone. They are saying
something else on a perusal of examination bid. We find para 7 that the contract of dredging petitioner to a deep one. Clause 2.3 refers to the definition of a site. Site means land. We may at this stage refer to similar work incorporated, definition of a similar work. Other clauses of the bid, so we did not find any infirmity in the bid. So, therefore, the
So look
point
at para 9, my lord. Your lordships have para 9.
point that you have told us that a para 9, read that.
Yeah, I'll place it. There are other clauses of the bid which indubitably point out that the contract for dredging which has to be awarded pertains to deep sea dredging and does not remotely connect with riverine dredging, in which the petitioner has the experience. Your lordship has that? So the petitioner is the lead, is Dharti. So my point is, in a joint venture, you have to consider the experience of me as well. I am marine. So how can you disqualify on the basis of Dharti being riverine? Dharti may have something to say, but this is complete non-application of mine. 51% for consortium, okay.
What happened? There's a tender of which
It's just a minute. So your lordships gave notice and you gave a returnable date. They did not file it within the before the returnable date. They then filed a counter affidavit, and the counter affidavit said that we have just awarded the contract.
What do you say?
This is the point now at my end level.
Okay.
You must consider, my lord, joint venture. Obviously, you
That
must
is sitting-
consider.
You are looking at so comfortably standing.
Yeah, and 2 crores, my lord. I might mention the differential between my price, our joint venture, and the.
What do you say? What do you say?
Yes,
My lords, I may assist your lordships first on the second point.
My lords, one
There is
last.
a counter affidavit.
Yeah.
I'm sorry, my lords.
It became a one-horse race. There were 2 bidders.
No, my lords, I will clarify on everything. Lordships may give me 30 seconds. Firstly, the second point raised by my learned senior friend, Mr. Diwan. My lords, before the Honorable High Court, only Dharti dredging was the petitioner. The petitioner at item 72, and the only case made out was. I'm sorry, my lords.
How does it matter who is before the High Court?
My lords, this was never argued before the Honorable High Court, is what I'm submitting. But assuming that it was argued, I may assist your lordships right away. Would your lordships please like to go directly to the tender? If lordships have the first SLP, item 72, Dharti's matter, please have my counter.
उसको miscellaneous complete करके pass.
It's a common count.
Yeah.
My lords, it is a common counter which I have filed in item 72.
Wait for a while. Wait for a while. Just call the matter. Let us. People are waiting unnecessarily.
Okay, wait.
Your matter is also there.
Let's
73.
73, my lords. This, let me just, my lords, this is a matter where there is already an interim order in our favor. The council has been extended because there are more now number of seats which are vacant. My lords, today.
Go ahead. We will call it after vacation. In the
My
meanwhile,
lord,
do the
may I say, no,
Just-
every time this is happening,
No,
please let me say, this
the
is my
writ is
application.
pending before the High Court.
Okay. There's
They have filed 2 applications now. One application is for vacation of the interim stay granted by this court.
I will explain
And the
about
sec-
my application, my lord. May I
and-
just explain?
And the second application is for quashing the denial letter dated 14/11/25, against which they went before the Honorable High Court. Though there was another remedy available, but they went before the single judge. Single judge did not give them the interim order. They should have challenged it before the division bench. They came here directly.
It is item 73 is yours.
Yes.
You are in appeal.
I am in appeal, but against an order of 3rd of October. After that, my lords, much water is flown. What they are doing is they are carrying it at both forums before the Honorable High Court.
3rd of
Single judge, the writ
Tell
is
us what
pending.
happened after that.
So, my lords, kindly have 16th October 25. There was a stay order granted in our favor. However, this Honorable Court said that you go and inspect the college. We inspected. There was a denial letter that for this year, this college is 2 years old. This is the 2nd year of this college. So we went, inspected, denial letter. Denial letter, they challenged before the single judge of the Karnataka High Court. Single judge kept the writ petition pending but dismissed the interim order. Against the interim order, they should have filed a before a division bench. They come here and they file an application for vacation of the
Today there's an IA is coming. Is it?
2 IAs, one for the vacation of
An IA today. The case is listed because of the IA.
Yes, only IA, because they say that denial letter quashing
For
that
vacating the
should be
stay.
done here and vacating of interim stay.
IA for the
Yes.
vacating of stay.
Now, my lords, 2 things I want to point out. This can't be my lords, argued like this.
But also, forget about that. So far as your case is concerned,
My lord.
now
The counseling is going on, my lords. These students can go
What has
in
happened? Even
college.
They have only put in some more conditions to what the single judge has only granted, 25-20. Is this a college which worked earlier?
1 year only. This is the second year.
Only
But
the
last
second year.
election, they said 4-5-year-old college. This is second year, not
The second year.
And my lords, the counseling, it's the third or fourth time mop up stray, because there are seats vacant in colleges which are already there having permission. Now, I say these students, out of 63, now 40 have gone.
All right, what, see, we will not take your interim application here. What you can do?
May I say one thing, Your Lordship?
You will pursue your matter there.
Just 2-3 hearings before, Your Lordship directed to move an application. Matters came up for hearing. I'll just tell it what happened. This is half facts are present, stated before this court. This is the case. In this case, every year I'm forcing to go to court because they're not responding. They're not doing.
Okay, we granted an interim order. We will not
My lord,
vacate it.
court.
Post it for final hearing.
No, for a moment.
Is this matter?
My lord,
Is this matter?
May I
for
say one
disposal?
thing for a moment? Even this year they did.
And this our order will not come in your way of pursuing your case there.
That can be observed because.
We'll observe.
My lord, just one thing. My
We will
lord.
observe.
Even now, 20th admission will close. Now already 1 year they.
We are saying keep it open ended. If it is possible, you take it there. I said post this matter for disposal in the second week of January. In the meanwhile, we make it clear that the pendency of the special petition will not have a bearing. Pendency of the interim order will not have a bearing on exercise of the remedies which the petitioner has already availed. Okay.
The respondent has.
Next, respondent has already availed. Call the next.
Here, one thing I just want to say, my lord, kindly see the deficiency, what the minor deficiency, they just want to shut.
Argue it there.
Minor-
Argue it there. It is not your petition. It is their petition.
Order is granted here.
That's why we clarified it that can be your petition can be heard. If an interim order is not granted by the single judge, that can't be a reason to vacate this. You file a writ appeal or you ask the High Court to recover. You do that.
My lord, order can it be released today, my lord? Because,
Yeah.
Because 17th, my lord, again.
We will do it.
I'm so.
As release kar dena.
May it please, my lords. My lords, I am for the petitioner here, and my lords, the issue is
Who are
that
you?
my lords,
NBCC.
NBCC. My lords,
Additional documents.
additional evidence. Now, one thing, my lords, kindly have, there were 8 documents. Whenever there is an additional evidence to be taken on record, there are 3 things which have to be seen by the Honorable Court.
Not going to interfere.
No, my lords, 4
Interim
documents have been allowed. It's not that I have been, my matter is dismissed. Now, my lords, out of 8, the Honorable High Court allows 4 documents.
Let it.
Therefore, the additional evidence will be taken up. Now, the rest 4 documents are all connected. The High Court comes to a conclusion, they are relevant, they are necessary, but only says that because you came late, so therefore, out of 8, 4 we will allow, 4 we will not. Now, my lords, once additional evidence is already now being considered, there will be a examination. Then, my lords, why even those 4 documents? Because if those 4 documents are not there, then these are all connected. It will serve no purpose. Kindly have these. Well, it's.
May I just.
Why this 50-50%?
May I just respond, Lordship? In fact, let's kindly have,
A fresh matter.
It's a fresh matter. Notice.
Kindly have, only one thing. Let's only one thing, Lordship. Only one thing, Lordship. Before
If you are ready, we will.
I'm ready, Lordship. I'm ready.
We'll ask them to allow all the documents.
Only 5 minutes, Lordship. Let's kindly have the issues framed in the trial, because this document which they wish to file, Lordship, pertains to 2024. Kindly have the issues. Issues is at page number 23.
Already allowed some documents.
No, let's kindly let the issue before the Honorable Court in a suit is that whether the contract was completed on 30th April 2016. Please have the issues, Lordship, at page number 23 PDF file. And internal page, please have, Lordship, para 5 of the impugned order. Internal page 3, PDF page 23, issues.
But why are you contesting so?
No, let's kindly see. The issue before the Honorable Court, the issue before.
My last friend would just be. My lords, I'm only saying one thing. Once the entire additional evidence is being taken, and these are.
It will change the whole.
Exactly what we
That's
are.
my lords.
May I just submit?
And it's not their SLP. They haven't come, my lords,
Let's allow them.
that order.
If you allow them.
Let's 2 things. The issue before the Honorable Court, which because it's my suit, I filed that I had completed the contract on 30th April 2016.
Okay, fine.
The project was taken over on 31st December 2016.
We will see what's the relevancy of it. Issue notice, so and so takes notice in the matter. List for disposal. Court खुलने के बाद, if you want whatever documents you put it, we will dispose it off. Court खुलने के बाद लगा देना first week में, second week में लगा लो. There is no need for any interim order because
Malad,
he is giving
there
you
is-
half.
The next date in before High Court is in March, my lord. So I am that way, it's fine. Status
week.
quo can be given because
Second.
if before the JR, my lords, of for the additional.
Okay, it will come.
My lords are giving me that status
What-
quo, my
what
lords.
state you want? No, nothing will happen. No need.
My lords, we'll come back in January and
I'll oblige you, Lord.
I am obliged, my lord.
Nothing will happen. Yes.
May it please my lordship, my humble apologies for not circulating the adjournment letter. The counsel is trying to appear in the VC.
My lord, I'm not well, my lord. Throat infection, that's why I'm requesting, my lord. Yesterday,
Doesn't matter.
down with the.
Much obliged.
Sorry, my lord. I'm praying apology, my lord.
It's all right. Next.
May it please, Your Lordship. Your Lordship, in this matter, the suit was filed against me on the plot of land, Your Lordship, marked by KP Dag number 141 and Patta number KP Patta number 141 and Dag number 17, Your Lordship. And what happened, Your
Question
Lordship?
was not you didn't
Your Lordship.
you didn't suppress the fact of possession having been
No, you have not
given to
suppressed.
respondent. That is why
No,
they
no,
filed it
no,
and
no.
vacated and
So,
vacated.
Your Lordship, position has not been suppressed. Your Lordship, if Your Lordship see the order, they have at that till today the order has been got. They have not annexed the last order. 30th. Your Lord, the question
It's an interim order. It's all subject to. We are not inclined to interfere with the interim order passed by the High Court.
Your Lordship is status quo because other third party rights will be created. Status quo is that.
Needless to say that the orders shall be subject to the final outcome of the case.
Your Lordship, in the meantime, may I another result? Because some questions of law has to be framed in the second review. May I give the liberty, Your Lordship, that question of
Okay, that you will have to
that
do.
Your Lordship.
They will do it then.
No, if Your Lordship give otherwise the question of law has been framed already. So that's why if you give a liberty, the other subsection question has to be framed, Your Lordship. Only two questions of
They
law.
should do it.
Your Lordship will give me that liberty. Otherwise, the court will say.
Ask the High Court, ask the High Court.
Your Lordship give me that liberty, Your Lordship.
You will not do that. That's not proper. Matter is pending. You ask which court will say, don't raise this question. Unnecessary.
I'm sorry, Your Lordship.
No. Why you sorry?
I was late with the what?
No issue. 21.
Not subsequent to this application.
Not made.
Yeah. Yes, not and subsequent to this
Withdraw.
application. I'll withdraw.
Dismissed is withdrawn.
Much obliged.
Next.
Well, just a few facts, Mullah. With respect to the financial year.
What is this, Mr. Sibal?
Mullah, this is in respect of Mullah's monies that we have to pay Mullah. Arrears that we have to pay. But in
Damodar Valley Corporation.
in the meantime, however, there is a refund that's ordered to me.
Oh, you want some kind of an adjustment.
That's
there.
correct. That's correct.
But these are two chocks. There are two. You succeeded there and then you got a credit there. You want that to be adjusted here.
Naturally, because in the meantime, on 15th September, the judgment came.
What do you say to that prayer?
Lord, in that matter, if your Lordship will recall, I'm appearing in that matter, Lord. There the issue is that there are two appeals pending before the APTEL. One was with regard to their refund and one was
Those will
for
be
my
subject to
recovery.
the appeal. That has not
APTEL
become
was-
final, is what you say.
That has not been decided and that appeal is still to be heard. So that is why don't link this. This is a different financial year. That's a different financial year.
Correct.
So
That's
don't
appeal
link
is
these
pending,
two.
is
That
it?
will be
Yes.
that will go along with what that is SLP is pending. Your Lordships have issued notice.
That is
in that
the
matter. Because
the
your
refund
Lordships
matter.
have also said that.
In that matter,
But
what
I have
Mr.
to recover
Sibal
from
is
the,
saying, when the APTEL allowed those appeal 15th of September 2025.
That's correct. These are the orders.
The remand order is that where did they succeed?
It's a remand order which asks me to refund within 3 months.
That's right.
Then we came here saying on the limited issue that my appeal is pending. I have to recover from West
Will
Bengal
again be
electricity
subject to the determination by the regulator.
Which expires today.
And thereafter, it will again.
It's
be
expired
subject to
today,
public-
Malad.
And this
There
is
was
a
a
different
direction to
financial
do it
year,
within
not
3 months,
what is the
expired
subject
today.
matter of
Okay, leave that. I
what
think
is
you mixing up.
the refund is a different
One
year.
minute,
Nothing to
one
do with
minute.
this.
Mr. Mixing these two may not be appropriate, but in this, what kind of an interim order did you?
That's what I'm saying, Malad. This relates to financial year 2018-20. Just note those facts.
1820. That was
18 to
914.
20, Malad. This relates to that, in which we are
20?
18 to 20.
Correct.
Right? And Malad, the order is 50% bank guarantee and 50% payment for arrears. Right? When this order was passed on the 11th of August.
11th of August.
11th of August 2025. In the meantime, for financial years 2009 to 14,
That we got the fine.
but just for a minute, Malad, the court ordered refund in respect of the same issues. Now, kindly, I showed to your lordship's page.
Not the same issue.
Of September 25.
Yes, so therefore we said now, and then the direction was to calculate the refund within 3 months, which expired today. They have not calculated.
Our question to you is.
No, your lordships have passed an interim order saying that.
We are just talking. The 15th of September 2025 is not a standalone order, but it will be subject to the decision by the regulatory commission with respect.
No. The only issue has been decided. That's why I was showing.
Why did it remand it?
For computation. What's the total amount? Just see 277.
Okay, one more question.
Yes.
Will it not be subject to appeal? Has it not been appealed?
It has been appealed, Malad. Your lordships have passed an order saying that don't give the amount. Your lordships have passed an order of issuing notice.
We are asking about 15/9/25.
I'm talking of that only, your lordships, Malad. They filed an SLP. Your lordships have issued notice and said, kindly see till the next date of hearing, final orders may not be given effect to. That we make it clear that we have not stayed the proceeding before the commission.
Regulatory commission's order, we have injuncted from power.
No. We make it clear that we have not stayed the proceedings before the commission.
Will not be given effect to.
That's right. Money will not be given to us, but the calculation had to be done in 3 months. That calculation, that expired today, Malad. They have not done it. Now I show to your lordships what the problem is. Earlier financial years, 2009 to 2015, 14, kindly see page 77, 277 and 279. Kindly see at 279 is the matter that the judgment starts, and kindly see page 291. It's the same issue.
Okay, ये यहाँ पर pending है. That was only the previous year was sent back. And tell us about the.
Kindly come to 291.
No. Tell us about this. The subsequent years of 2018 to 20.
Same issues, Malad, in the previous year. Same issues in the subsequent year.
Appellant deposited.
Right.
So that which stage is that? Just tell us about 18 to 20 again.
18 to 20, Malad, the order that was passed was on 11th of August. Payment of 50%.
Aptel, no?
Yes.
Aptel.
And payment of 50% and bank guarantee of 50%. Appeal is pending.
Oh, against that you filed an IA.
That's correct.
For adjustment.
In the meantime.
No.
After
extended time for completing on 4 weeks.
That's right.
That order is unchallenged.
Which we got, Malad. We got 4 weeks. And then, Malad, what happened was that in the meantime.
They disposed of your IA and said they can't be clubbed together.
No, but just for a minute. 291. Right. I just explained why they should be clubbed. The issue was whether short recovery from the other distribution licensees can be recovered from the command area consumers. Your Lordship sees issue 1 at 291.
291.
Issue 1, Malad. It's the same issue that is in the subsequent year. There's no difference. By that time, the final order had not come, Malad, of Aptel.
Aptel ka?
Yes. When the earlier order was passed, this final order had not come for in a previous year. The same issue. Kindly come to whether short recovery from the other distribution licenses can be recovered from the command area consumers. See the finding at page 302. See the finding at 302. Para 57.
You are all industries, is it?
Yes.
You are all industries, is it?
Yes.
All industrial consumers.
How
Registered,
come an association comes?
association, Malad, that matter is pending in APTEL itself, Malad. That is not the subject matter of this court. Even the industry is there,
So
Malad.
you're all industries, you group
Even
together.
the industries are applicants, Malad. There. That's not an issue. That's not an issue. Here also, Malad.
Suppose that interim order gets varied,
Which interim order? Malad?
that order where you got now the credit by virtue of the 50%, the earlier order,
There's no credit.
2019 to 14,
There's no credit.
computation is already done.
That is unchallenged. That order is unchallenged.
It's about 940 crores that they owe us, according to us. This recovery is 80 crores, 84 crores. So we are saying, please don't force us to pay 84. Please calculate that and adjust it. What's the problem, Malad? Kindly see now page 302, the finding.
8?
Page 302 on the first issue, Malad, of the short recovery.
302.
Yes. Para 57. Even if we agree, I'm sorry, Malad. Lordship has that? Even if we agree that it's a revenue neutral entity, it cannot recover the arrears attributable to West Bengal State Electricity Board and IPCL from the firm consumers under the law. We've already held that loading of under recoveries on account of the said discoms on firm consumers arbitrary and contrary to the principle of the governing tariff. And then 58, the present situation is such that the command area consumers are indirectly cross-subsidizing the other discoms. Such a situation is not only illegal but contrary to the statutory objective. Now, this applies to both 2009 to 14 as well as to 2018 to 20. But that judgment had not come, but that came only on 15th September. That's issue number 1. Come to issue number 2. That also is in our favor. And the amount that we have to recover is 940. They are purposely not calculating that, Mullah, and they want us to pay 84 crores, Mullah. As your lordship knows how difficult it is now.
Vikas Singh, what's the difficulty in adjusting it?
Lord, can I now explain, Lord? Firstly, this order, which is 11th August, was inuring to the benefit of 31 consumers. Against 31, Lord, only 13 have come, 18 have paid also. So these are those 13 people who don't want to challenge, who want to challenge that order of 11th August because there is a carrying cost. So 18 have already paid. Now, Lord, this order, which has directed the refund, if your lordship will recall, why did your lordship say not to be given effect to? Because in that order, there is a huge fallacy. There were 2 appeals going on. My appeal in the APTEL saying that I should not have been asked to less recover from the West Bengal Electricity Distribution Company, which is the DISCOM, because in my view, I had given them supply in the radial board. I had to take supply as a consumer.
Not even parties there.
And their appeal was that short recovery has wrongly been covered, taken from me. The 2 appeals were tagged together. Mine was not decided, theirs was decided. So I came here, your lordship gave me that protective order saying that you will not, final order will not be given.
This, you please put
as far as Mr. Civil, let me now
decide the matter.
As far as the computation is concerned, computation is not to be done by me. That is to be done by the commission.
Yes.
This is not something to be done by me. The remand order is to the commission. So he's trying to paint me as if I am the commission. I have nothing to do with this.
Get the point. There is also a point in what you're saying, but it's only an interim order with some kind of an arrangement.
That's right. And they've already taken advantage of this order for such a long period of time. First your lordship's order, then the APTEL order. This
very well. We'll give a date and we'll.
And your lordship, they will not disconnect. That's all, Mullah. That your lordship is already protected.
It's disconnected and gone. No,
I'm back.
Your lordship is already protected.
Don't disconnect it. We'll take it up in January.
Yes.
Okay, Mr. Vikas.
Very well. Very well. Sometime early January.
Yes.
If your lordships may recall, Ms. Babbar had filed 6 SLPs on a similar point of adjustment, citing the same judgment. In this case, these parties never asked for adjustment from the APTEL. All they wanted was more time. APTEL gave them more time.
You think you're tentatively, you're right. We'll see.
Early January, my lord.
40 plus 30 students have been admitted as against a management quota. They are studying.
Has anybody come?
My lord, I apologize.
Yeah, what is to be done in this?
My lord, I appear for the MGR University. I'm not for the Pharmacy Council.
There was some. Every time it's coming like this and every time it's going off. All of you don't come. You'll coming in one after another.
My lord, I apologize.
We just find out with them. It's an item. What's up? 40?
67.
It's a 25-26 is the issue.
Current year.
What about the previous years?
38.
My lords,
They have had the permission, but this only thing is that everything was approved and the amount to be deposited got somehow delayed. That's all.
my lords, may I say this?
No, my lord. I'm sorry, my lord. I'm updating online, my lord.
1 minute.
College need to submit the standard inspection
1
form
minute, 1
along with
minute.
the fees.
Misha, tell me.
My lords, insofar as MGR University consent for affiliation is concerned, this college was established in the academic year 2019-2020. Since then, they've had the affiliation.
Affiliation, no problem.
So, my lords, insofar as the affiliation is concerned, I can only assist, my lords, insofar as affiliation is concerned, Pharmacy Council will answer for the payment process.
Where is the government?
My lord-
I thought you were saying Misha is appearing for the government.
My lords, I appear for the government at the MGR University, so their role is limited insofar as this thing is concerned.
But counseling and everything is over now.
My instructions are that it's over. There were 3 rounds of counseling and it's over. In fact, there is an order passed by my...
So now if we permit them, are there no students available?
My lords, I'll have to take specific instructions on that. Inadvertently, the matter was not noted in my list today, which is why I couldn't assist my lords on this. My lords may have it tomorrow. I'll take instructions whether
Come
there
tomorrow.
are seats vacant.
Find out, take instructions also from Mr. Ajay Kumar. He will also.
But my lords, may I...
Yes, I am here, my
If it's
lord.
over, we can't do anything. If it is not over, we'll help you out.
Is over is my instructions, my lord.
Tomorrow.
My lords, may I also, so that
Oblige, my lord.
Learned senior can answer this. I am told insofar as the university is concerned, for granting affiliation also, they are not compliant. So, my lords, even if my lords was to pass an order,
What they do in the last moment, they will come, they will hide everything.
70 students are as of now studying, my lord.
We go out of our way because we think that some students are there.
Yes.
Students are not there, Mr.
70 students.
You will
Management
have to
board.
take students, you will have to do affiliation.
My lord, already, my lord,
Tell us also about the affiliation, you find out and tell us tomorrow.
please, my lord.
You were saying about the, okay, tomorrow.
Obliged.
You are in ICU.
70 students are studying, my lord, management quota.
How can you study? You have not even admitted. Previous years is all right, but
May I explain, my lord? I got instruction from the.
so illegally you have taken them in,
Not illegally.
collected fees.
Usually, my lords, before the start of the admission process, they will recruit, my lords. Now, my lords, the approval will be given during the mid-year. Now, the amount is already deposited with them, 22 lakhs. They say you have to deposit again. We say it is already done. That is the
After
only
deposit,
my
you would
lord.
have, if you had deposited in time, you would have participated in the counseling.
It was there.
If you had participated in the counseling, you would have taken.
Website glitch. It's there in the writ petition also.
My lords, payment would not entitle them to affiliation unless in inspection they are found compliant.
No, this is license. Affiliation is different. This is the first time you're raising it. I'll just confirm with it. That's not the issue.
That's why I...
Nothing we
That's
can
not
do.
the issue.
Difficult. Next. 17. Shall we take up later day your matter?
Otherwise, my lord, it's a fresh matter. Notice was not issued.
Which one?
No, my lord. No, my lord, please.
Which one?
The 70 number, item is 70.
It was
1 minute. No,
Not a
it's
fresh
not-
matter, It was
Not a fresh matter. This bench is hearing.
It
I
was
had
heard,
earlier.
was reserved, then it was.
I had heard earlier.
Yes, my lord.
My brother was not there.
Please, my lord.
So because of some difficulty, it was discharged. So we took it up. So we're going to hear it.
It's a
So-
consent order, my lord.
Huh?
Consent order. The impugned order is a consent order, appoints an arbitrator.
No. Some merits of the matter. We'll hear it. We'll hear you. Come tomorrow, Kalle. Come tomorrow. We'll hear you.
Please, my lord.
Tomorrow we'll hear you.
Please, my lord. Oblige, my lord.
We'll hear you. Don't worry.
Yes, my lord.
Your Lordship,
It was heard. It's our difficulty.
Lordship, I apologize. Can I mention item 12? Mr. Nachiketa Joshi, learned senior counsel, was online, but he couldn't. He just wanted to make submission in item 12, Your Lordship.
What needs to be done?
Lordship was gracious enough to issue notice, but I think the stay aspect couldn't, and he wanted to make some submission.
Whatever. New rules of option for the state of MP. Okay, stay.
Stay.
Next.
Obliged, Your Lordship.
Yes, Shyam.
Yes.
My lords, I was assisting your lordships on my reply.
Yes.
So if lordships can have, item 72.
Yeah, my learned friend was on his legs. May I just take 2 minutes? There are 2 documents I want to show so that my learned friend can then address the court. They're just 2 documents. So if your lordship would just take up the...
We are still at the admission stage.
Yes,
I
so
think
we
you have
thought we
made out a case. You have made out a case.
Yes.
But
No,
then
so I
tell
want
us
to
what
just
it is.
complete it, my lords, because then your lordship will dispose it of one way or the other tender. So if your lordship just takes up
Who is the successful bidder?
the successful
My
bidder,
lords, an entity called Rock and Reef.
You
Rock
have
and
to
Reef.
hear them.
Rock and Reef
Have
are
you
not
given the
parties.
contract to them?
Just
My
after,
lords,
after
the
Honorable
contract is
Lordship
awarded.
notice.
No, my lords, let me clarify because Mr. Divan,
No,
right
one
off
minute,
on his.
1 minute. We are almost in the middle of the arguments.
Yes.
Has the successful bidder made a party here?
No.
No, my lords, they have not made the successful bidder a party.
Because there was no award which was made until after your lordship issued notice.
Ask them.
And there was a time which your lordship prescribed for filing a reply. They didn't file it, but we can't raise an objection to that. They've
Has
filed
the
a reply
contract been
now.
entered into in favor of a
Yes, now they wish to
Yes, yes, my lords, the contract was entered into at the stage of High Court itself. Work order is awarded now.
Yeah,
At
work
the stage
order
of
is
High
now.
Court itself.
But then
Contract is already entered
we
into,
can't pass
work
an
order
order
is
without
awarded.
hearing them. We can't pass an order without hearing them.
And my lords, I was running against the clock. My 3 ports are going to be non-functional if I don't
Doesn't
start
matter.
dredging.
If it is wrong, we will set aside that order. That doesn't
Absolutely, I am in your lordship's hands. I am ready to assist your lordships
matter. The
whenever.
point is that we will not. How can we pass an order without hearing
What is his name?
a successful bidder in whose favor a contract has already been executed?
As your lordship suggests, we can make this successful.
You take out Dusty.
All right, so your lordship will, on my oral application, make Rock and Reef Dredging Private Limited a
You
party.
file a
respondent.
formal application.
Okay, we'll file it in
So
the
counsel for the petitioners. No, at the request of Mr. Shyam Diwan, learned senior counsel, we make so and so a
Rock and
party
Reef Dredging Private
become
Limited.
a successful bidder in whose favor contract has been awarded to be made a party during the course of the day.
Yes.
Yes.
Thus issue notice to the newly impleaded respondent. Thusly, in addition, list the matter for disposal. Second week में लगा देना.
For disposal, yes.
Huh?
The
Second
notice
week.
will indicate that it will be finally disposed
Yes,
of
yes.
on that date. Okay.
This will for yes, both the matters, both the matters. Both the matters.
Yeah,
Lordship.
I just wanted to show my lords on the next date, whenever lordship
Sure,
clear
sure,
the
we'll
matter,
hear you.
Yes.
that I am also duly
Yeah,
qualified.
both.
My rejection of my bid on a technical issue was wrong.
Yeah.
So that point I have to make
That's the
good.
implement
We'll hear you.
order,
He has
same
made
order
out
in
a
both.
case that, but we haven't heard him.
Yes.
Lords,
He has made out a case, but we'll see about the contractual, how they got over it.
Correct. Well, same order in both.
Same order, same.
the issue before the High Court was the technical
It's
disqualification.
okay, Tapesh, we'll
Yes.
hear you. We'll
Lords,
hear you.
Grateful.
Grateful.
Immensely.
Your colleague has gone.
No, my lords, I am here to assist your lordships.
No, not you, not you.
I'm sorry.
Okay, we will take it up tomorrow. That's what we said, right?
Yes.
We'll take it up to that matter. We'll take it up tomorrow. No issue. Tell him. Tell him.
Great.